It is Lordship. I seek your Lordship the indulgence for moving an unlisted motion today, Lordship.
Today?
Today.
What agency is there?
I have been blacklisted without a show cause notice. My company has been blacklisted.
May I mention item number 31, Miller, with the consent of other side?
Yeah.
It may come out 22nd of April, Miller.
You are applying for?
Petitioner, Miller.
Your good name?
My M. Sahewala.
On request made by M. Sayawala, learn consultation.
22nd of April.
Less than 22nd.
Yes, Your Lordship. My Lord, I pray for urgent listing of a matter on Monday, my Lord, for motion.
Why?
My Lord, by the impugned action, besides termination, bank guarantee has been invoked, been debarred also, my Lord. It's an arbitrary action, my Lord. The takeover can happen anymore.
I'm paying for listing of a writ petition, my lord. Next week, my lord, 28th, my lord. Your lordship already had the matter, my lord.
What letter?
My lord, cancellation of license, my lord. 27th, my lord.
Huh?
27th, my lord.
So next week, we'll have it on 1st April.
Okay.
May I please, Lordship? Lordship, I beg to mention item number 28, Lordship. I would like to withdraw this petition, Lordship. Lordship, matter is already settled, Lordship. Settled on for market, Lordship. So, Lordship, not press, Lordship. I would like to.
You have settled between the parties.
Yes, Lordship.
Mr.
S.J. Sohoria, Lordship.
S.J. Saharial and the counsel for the petitioner suppose that the parties have settled the matter outside the court. And accordingly, he has instructions to withdraw the writ petition. Who appears, BTC? Mr. B. Google, Learned Standing Counsel appears for the GAT department, for the GAT, huh? Which petition is dismissed on withdrawal.
May I please, Your Lordship? Lordship, I beg with the consent of the other side, I beg to mention item number 60 and 61. Lordship, here we have filed a rusty affidavit in compliance of order dated 5/3/25 in both the matters, 60 and 61. Also, they have filed the affidavit also, but the affidavit had not been tagged yet. Let it come after tag with the record after 1 week.
Who filed the affidavit?
We have filed a dusty affidavit. We have taken the steps in compliance of order dated 5/3/25. Also, other side has filed the affidavit in oppositions. Let the matter come up along with the, after taking the affidavit with the record.
On request made by
S.A. Bhaktiyar.
Learned Counsel for the petitioner, list after 2 weeks.
2 weeks. 60 and 61, both items.
So, 2 items, both. Okay.
Also, may I please, Lordship? I beg to mention for listing of writ petition, Lordship. It is a matter pertaining to termination of mining lease granted to the petitioner. Lordship, I beg for listing on Monday, Lordship. This is urgent, Lordship. We have filed the affidavit, Lordship.
Witness day 26.
Wednesday. Much obliged.
May it please your lordship. Lordship, item 27. This matter, lordship, it has become infractious. So into withdraw that matter.
MS S. Dev.
Yes, Dev.
Learned Counsel for the petitioner submits that the matter has become in practice. Who appears? PWD.
PWD.
PWD was B. Gogoi, isn't it?
P9.
Mr. B. Gogoi, Learned Standing Counsel, appears for the PWD. The petition is disposed of as infractious.
Obliged, lordship.
Lordship, may I please for listing IS 2782 of 2025 for orders, Lordship,
What is that IFO?
to vacate the interim order.
Okay, when did you file it? When did you file?
Uh,
It is
2025.
Lordship.
26.
Month.
1st of
14 month.
April.
You want it on 1st April?
Yes, Lordship.
Okay.
Obliged.
May I please, Lordship? Lordship, item number 29, Lordship.
Yeah.
Lordship, matter may come up after review vacation, Lordship.
You are Mr.
D. Kolita.
On request made by D. Kalita, Learned Counsel for the petitioner. List up to the BU vacation.
May I please, Lord? Lordship, with the consent of the Lordship petitioner, Lordship, I beg to mention item number 34 for response number 2 and 3, Lordship, on behalf of S.S. Roy, Lordship.
Okay.
They have given a consent from BPCL authority, response number 2 and 3. I've informed in my authority.
Yes.
Oh.
Yeah.
You are the petitioner's counsel?
I'm
Okay, heard, Mr.
presenting on behalf of M. Datta.
Your good name?
S. Das.
Yes, that's learned counsel appearing on behalf of Mr. M. Datta. Learned counsel for the petition. On request made on behalf of assessor, learned counsel appearing for the respondents to entry. When do you want?
Sir, any day it's after 2 weeks.
After 2 weeks.
Deeply obliged.
May it please, my lords. My lords, I beg to mention a matter, 2015 writ petition, my lords, for listing. It was last listed on 28th of January, my lords.
This month, this year?
Any date, my lords, convenient to my lords.
Okay. 4th April.
4th April. Deeply obliged.
May I please? Well, I have an urgent petition, my lord. Eviction matter, my lord. Later matter come from listing Monday, my lord. Eviction, my lord.
Okay.
Fine.
May it please the lordship. Lordship, I beg to mention item number 52. We have instructions to withdraw the matter, lordship. It has become infructuous.
MS,
M.
you
Kakuti.
learned counsel appearing on behalf of Mr.
Lordship, the Justice Kaushik Goswami was engaged at that point of time.
You appearing?
Lordship.
Okay, MS, so and so.
M.
Learned
Kakuti.
counsel for the petitioner. Submits that the matter has become infructuous.
Lordship.
Matter has become infructuous. Stop. Water resources.
Lordship, I had informed, yes,
Okay, with petition is accordingly disposed of as infructuous. Yes.
obliged.
May it please your lordship. Lordship, with respect to item number 54, the same has become infructuous.
54.
Yes, lordship.
They've complied with the order.
Lordship, I am for the petition.
They've complied with the order.
Lordship, no. It was 2021 matter only, lordship, pertaining to settlement of fishery.
Oh.
Same has become infructuous.
Mr.
Lordship, HR does.
HR does learned counsel appearing on behalf of
Lordship, Mr. D. Kalita.
Mr. D. Kalita.
BD does.
Mr. B.D. Das learned counsel submits that the matter has become infructuous. According contempt petition is closed.
No, with the consent of the petition, I beg to mention item number 39, my lord.
Huh?
Item number 39, my lord.
Yes.
Consent of the petition, may be taken after 3 weeks, my lord. In the meantime, I will file my affidavit, my lord. I am for the respondent.
Who appears for the petitioner?
S. Day, my lord.
You have taken the.
Yes, I have taken the.
Okay, on request made by S. Bora, learned counsel for the. You are the standing counsel or counsel?
No, I am appearing as a counsel, my lord.
Learned counsel appearing for the respondents to entry. How much time you require?
3 weeks, time.
3 weeks time is allowed to file counter affidavit. List after 3 weeks.
No problem.
62 of supplementary list withdrawal.
And we allowed to withdraw the petition.
Simple withdrawal.
Simple withdrawal, my lord.
Okay, Mr.
M. Sahiwalam.
M. Sahiwala, learned counsel for the petitioner. Praise for withdrawal of this.
No.
Mr. G. Bogalia, learned government advocate, appears for the state respondents. With petitions dismissed on withdrawal.
Deeply.
One of daily list motion.
Mayor, your lordship, this contempt petition has been filed alleging deliberate violation of the order dated 1/8/2024 passed in WPC 4441 of 2020. Lordship will find the effective portion at page 14. Lordship, if I may read para 4. In view of the state respondents in PWD of Mongoldo and Dolgaon Territorial Road Division and Udalguri RNB Division, having admitted that rupees so-and-so totaling 17,58,000.
Mr.
M. Das.
M. Das, learned counsel for the issue notice. Petitioner to take steps on for service of notice on all the respondents by registered proceeding within 1
Obliged, lordship.
list after 4 weeks.
2.
May I please, the contempt petition, my lord, the order is at page 8, relevant page 9. Page 9.
Not yet paid. But Mr.
And Hawk.
N. Hawk, learned counsel for the petition issue notice. Petitioner to take steps for service of notice on all the respondents by registered proceeding within 1 list after 4 weeks.
Well, item 3 and 5 same. Same.
Same
Same,
respondent?
same. Work order is different, but same order.
No, okay.
3 and 5. Please, ma'am.
Same order. 3 and 5, huh?
Topics.
4,
Lordship, page 11 is the order. 20/1/2025. Lordship has directed to dispose the representation considering the facts. Page 13 is the relevant question, para 9. Till date, nothing has been communicated.
Okay, let me pay SQ Goswami and issue notice. Petitioner takes steps for serving of notice on the sole respondent by registered proceeding within 1 after 4 weeks.
6 to 10,
Look, these two may be taken over, whether I have received the instruction just now, madam.
Hurt Mr. P.
Bora.
Bora, then a counsel. On request made by S. Bora, then the standing counsel SSA. List the matter on
Relative.
26.
Approved.
11,
May I please, your lordship? Lordship, my name has been marked as a D since 2005-6, lordship.
What? You mean,
This is debuter matter, my lord.
huh?
So some orders are there, my lord, whereby the Sonapur court has remanded the matter to the SP to scrutinize the matter, then place the matter before the, my lord, the Tribunal, Foreigners Tribunal. Some similar order.
Similar order has been passed by.
May dispose of on that line, my lord.
Photo. Does it concern my bench? Huh? Huh? This is an FT matter, isn't it?
FT, my lord, debuter matters. Debuter matters are, my lord, the single bench matter. Debuter is single bitter. Those where there is no opinion, those are coming before the single bench. And those where there is opinion of the tribunal, then it goes to the, my lord, the division.
Does it concern this bench?
Civil bench court.
Uh-huh.
Yes, ma'am. My lord, see, there are two. These in these cases, my lord, they are not yet sent to the tribunal, my lord.
Just a open bench.
By notification, it is sent to single bench. Earlier, it was taken by the division bench only.
No, even if it is single bench.
Yeah, single bench.
This is bench 4, isn't it? This bench 4.
Yes, bench 4.
Okay. Were the orders passed? Okay.
There are numbers of orders, well. So SP may examine and place the matter before the foreigners tribunal, concerned foreigner. That must only.
Okay, heard Mr.
Uddin Lordship.
Uddin.
Uddin Lordship.
Uddin, learned counsel for the petition. Union?
None. My lord, for union,
Who was appearing?
union K Gugoi may be good. No?
Okay, Gogoi, you can appear for the union. Mr. K. Gogoi, learned CGC appears for the respond number 1.
I will appear for my lord J Payang for respondent number 2, 4.
And J. Payang, learned standing counsel
Yes, my lord. Standing counsel for FT and NRC, my lord.
for FT and NRC appears for respondents.
2,
3,
3, 2, 4, my lord.
2 and 4,
2, 4, 6, and 7, my lord.
6 and 7.
And my learned friend, he will appearing for respondent number 3.
Mr.
AIL.
Yeah, learned standing counsel, election commission appears for the respond number 3. And Mr. M.
For respondent number 5.
learned government advocate appears for the respond number 5.
Respondent number 5.
Para. Which voter list?
2006 Lordship, kindly case 19 Lordship.
The grievance, the petitioner, is the action of the authorities in marking with an inverted comma D against the name of the petitioner in the voter list of what? Of which village?
Holdivari Lordship.
Hmm?
Holdivari.
In the voter list of 87 Holtipari. Correct.
Lordship.
87 Holtipari. Your voter
Yes,
list.
yes, Lordship. 87 Holdivari, part 2.
Part 2. You will get it in page 19. Under which, under the 39 number, Jaliswar LSC. Stop. It is the case of the petition that such marking was made without any notice
Yes.
or intimation or even verification of any documents. Stop. The further case of the petitioner is that either he or she, he,
Mamoni, yes.
that he is a permanent resident of which village? You are permanent resident of what? Council. You are permanent resident of?
Holdivari Lordship.
Is a permanent resident of Holdivari village.
Yes.
PS.
PS.
Nagar.
Huh?
Nagar.
Where can I get that?
PS Luckipur, my lord.
Luckipur Lordship.
Huh?
PS Luckipur. Luckipur Lordship.
Page 3, my lord.
PS Luckipur. Stop. The petitioner further claims that she is presently residing at
Village Holdivari, part 2 Lordship.
village Holtipari, part 2. Under the 39 number Jaliswari LSC in the district of
Goalpara.
Golpara. Stop. It is the case of the petitioner that due to the action of marking D against his name. No, cancel it. Huh? The learned counsel for the petitioner accordingly prays for a direction for consideration of his case and direct the appropriate authority for removal of the D from his name. Stop. Then from here onwards, A to Who is the superintendent of police?
Golpara.
Golpara, my lord.
Golpara. Is a border.
Yes, superintendent of police border.
Border. Golpara is required to be mentioned
Yes, my lord. SP border.
in the third para, no? Superintendent of police border numbers, border Golpara, huh? Respond number 6. Okay, this one. I'll mark it. Well, I'll mark it in blue.
I think 15 and 20 also, my lord, same.
I may be rank for 15 lordship. And I am a resident of different village.
Voter list and different.
Voter list,
Voter list is 18 lordship. Type could be 2005 voter list lordship.
2000.
2005 voter list. Page 18.
Okay. Which village?
Village is lordship Gusaidubi Hindupara. 60 number Gusaidubi Hindupara.
Where can I get that?
Lordship in the voter list it's a page 19 may kindly be seen lordship.
19 is in vernacular.
Yes lordship and
I
in
can't
the
read it.
cost title I have mentioned lordship. Page 3. Page 3.
Side to be Hindu.
Hindupara.
Village is Gusai to pick into Para, first title. Then LSC will be 39 Jaliswa LSC.
Same, same.
Any other?
PS is Lokipur lordship here.
Lokipur. PS is same, Lokipur.
PS is Lokipur.
PS is like,
Others are same. my lord.
and then respondent 6, same.
Same.
It will be superintendent of police within bracket border. Yes. And Golba. Can you do it? Yeah, if there's any specific thing.
20, my lord.
Item
20. But this one was, my lord, 15 earlier. Now 20 also same, my lord.
I'm 63 of something.
Concept of
I'm 63 of supplementary list, similar matter. 63 of supplementary.
63 also, that is same.
Same.
Same order will be in 63 also.
But voter list is 2005 lordship. And village is different lordship, Gumaijar.
Where's the voter list?
Is 21 lordship, particular.
Voter list of 2005. Huh? LSC is number 39 Jaliswa LSC.
PS is same lordship,
Police station is
Lakshipur.
Same. Luckily.
in the first title. You'll see Luckipur. Respond number 6. Same. That's all.
Yes, ma'am.
Yanuddin lordship. Yanuddin Lanet.
That was item
63. 12 of daily list.
That was item.
My lord, in last occasion, my lord, he was actually on the inspection.
It was item 20
That-
also.
Settlement of market, my lord.
Otherwise, that was you will have.
Devising.
You can go in the morning to the site. Because if she goes, then there will be some problem, no?
Dukarin bam.
No, after that, he looks at fixed for the army.
Ede koi, ede better. A pillar has taken.
There were two complaints, my lord. both were result in negative, my lord. Lordship fixed the matter on April first week, my lord. This matter will
By
become
this time it will
infractuous.
be, my lord. By this time, my lord, only 2 days I will get, my lord. Because no problem. I
On
offered,
38th,
yes,
my
my lord.
lord.
By virtue of state, I will be content.
Yes, yes.
Okay, heard Mr. PJ Manda, learner senior counsel, assisted by Ms. P. Sharma for the petition. On request made by Mr.
As doctor.
S. Datta, learner standing counsel,
PNRD department.
PNRD department. When do you want?
April first week, any date, my lord, that on that day matter will be infractuous.
Infractuous. We're having court on Saturday. I want both of you to come on Saturday, so we'll fix it on 5th.
My lord.
To help.
Keep class.
I love it.
13,
My lord, petitioner, my lord, created a contract work, my lord, and the bill was submitted. But the bill, my lord, is yet to pay by the respondent, my lord. That is,
Amount 10 lakhs.
my lord, 10 lakh, 13,906, my lord.
Heard Mr.
M.A. Islam.
M.A. Islam, learner counsel for the petitioner. By way of the present petition, the petitioner is claiming for outstanding dues amounting to 10,13,906. Stop. Anybody? Legislative Assembly.
Yes, madam.
1 and 2, I am paying for 1.
Okay, Mr. G. Bogalia, learned government advocate, appraised for the respondent 1 and 2. PWD. Mr. B. Gogoi, understanding counsel PWD, appraised for the respondent. Notice the respondents are passed. Our extra office respondents are notified after this 4 weeks.
14,
My lord, matter relates to non-payment of admitted liabilities of the contractor, my lord. So at this stage, my lord, notice may be go, my lord.
3 lakhs.
3 lakhs. PTM.
Heard Mr.
DM not.
Learner counsel by way of this petition. Petition is claiming for payment of outstanding dues amounting to rupees 3,68,797. Issue notice. Irrigation.
Number 1 now. I will provide the name, Lordship may issue notice, I will provide the name.
MS.
Name is not reflected, otherwise she was there, Lord. I will provide her name.
Learner counsel.
Miss DS Nyok, I think, my lord.
Yes, no, sir.
No. Earlier in some connected matters,
Okay,
Miss DS.
whatever, let go.
I'll
Give
provide.
let's appraise for respondents. 1, 3.
1, 3, 6, 7,
4, 5, and 6. Correct.
Lordship.
Finance.
2.
And Mr. B. Gogoi, understanding counsel finance, appraised for the respondent. Notice on responder complaint, however, it's the office, responder all over file and list of the 4 weeks.
16,
Read, please, your lordship. Lordship, similar matters are fixed on 2nd of April.
Okay, heard MS.
KK Chaudhary.
KK Chaudhary, learner counsel for the petition. On request made by Ms. D. Jain, learner standing counsel.
Water Resource Department.
Water Resource Department, list this matter along with WBC number
1872 of
What?
2023.
23 on 2nd August, April.
Okay. Oh, bless you.
17,
Well, here petitioner before lordship, my lord, the contractor, my lord, who had participated in the tender process, my lord. Pursuant to, my lord, NIT dated dated my lord 16/8/2024, my lord. Page 19, my lord. Here, package number at serial number 5, my lord.
Nalbari.
Yes, my lord. And after participating, my lord, in the tender process, my lord, the petitioner was found to be alone, my lord. Kindly come to
Lordship,
page.
like, I'm sorry to waste your time, Lordship. Lordship, can this matter be taken after some time? Council BOI will appear, considering this is a tender matter. Let it be handled by him only.
Okay, wait for some time.
Much obliged.
Okay. 18.
Non-payment of contractors bill, my lord. Outstanding is 711,064. Admitted amount on a page, kindly peruse page 28, my lord.
7 lakhs.
711,064.
Okay. Hurt Mr.
Not
Leonard, senior counsel assisted by?
No, I'm not a senior
Okay,
counsel.
okay, Leonard counsel appearing for the petition. Stop. By this petition, the petitioner is claiming for payment of outstanding dues amounting to rupees 7,11.
711,064.
064. Stop. Issue notice. Fisheries.
Fisher.
I will inform
Who?
P. Sharma, lord.
Mr. B. Sharma.
P. Sharma, P. Sharma.
B. Sharma, Leonard, standing counsel fisheries. Appears for respondent 1, 2.
1, 2, 3, and 4 also, lord.
4. About this 5.
5 plus a notice may go, lord.
Okay, extra copies. Petitioner to take steps for service of notice on the respondent number 5. By registered proceeding within 1 week. Respondents are allowed to file affidavit. List after 4 weeks.
19.
May I please your lordship, my lord, yes. We have prayed for extension of lease period, my lord. There is the replication we have filed. That we have been, our term has been expired on 25/1/24. And the
1 minute. Yes, please.
yes, ma'am. The petitioner was earlier settled with the fishery concern, my lord, by order dated 27/9/2016, which has been expired. The lease period has been expired on 25/1/2024. So, my lord, there is a provision of extension also, my lord, in the government fishery. If there is any loss occurred or loss caused to the fishery concern. In this case, my lord, there is evidence that there was a.
Where's your settlement order?
Yes, that is annexure 1. No, sorry, annexure 2.
Page 17.
Page 17.
Hmm.
This is for 7 years. And the settlement period commenced from 26/1/2017. Though it is order has been passed on 27/9/2016, but the settlement period has been commenced from 26/1/2017. Now, my lord, meanwhile, there is all we know there is a COVID-19, my lord, in the natural calamity, my lord. Then also, my lord, the fishery concern was enclosed by several enclosures, my lord, nearly more than 120 bigas. 120 bigas of land has been enclosed by the enclosures. So all these things, my lord, we have filed a representation before the authority, and accordingly it was processed, and thereafter a report has been prepared by concerned Mondal. A report has been prepared. Your lordship will find another page 19. Barnicular is there, page 19.
Context you're likely referring.
Yes.
With reference to the cited above, it is informed that land measuring 34 bigas, 5 laches of dark number so and so, and land measuring 170 biga, 2 kata 70 dark number so and so, and land measuring 102 biga, 2 katas 19 lakhs, dark number so and so, of Borgupa bill, that is the fishery, of Bogriland village of Horukhetri, Mouja within Sorthabari revenue circle on spot verification, land measuring, 110 bigger found under encroachment by nearby villagers having constructed houses, ponds, etc. Therefore, thereof besides cultivation over enclosed land of the bill. So these are the, my lord, the bill has been enclosed by the enclosure, nearby enclosure. These are the causes has been shown, my lord, which is the only ground to extend the lease period, my lord.
Actually, they are not in possession. And extension comes whenever they are in possession, lordship.
No, that is to be examined by your lordship, my
Lordship,
lord.
it is illogical to ask for an extension after possession is just, lord.
No.
If you give the possession, it will consider
It
as
was
direct
not
settlement.
given to possession any other, my lord. Not just NIT has been issued, my lord.
He could have approached before. He missed
No.
the bus already.
We have already been approached, my lord, and it was also mentioned, my lord, in the government, that is Deputy Commissioner letter. Another 5 may kindly be seen, my lord.
It's a simple thing, lordship. Extension, they are not in possession. They should have applied while he is in possession, lordship.
Kindly go through this one. There is a forwarding of the Deputy Commissioner.
Let it be. But you are not in possession at this moment.
Yes, we have automatically after the expiry, the bill will be taken by the government.
What is the question of extension now?
Why not?
1 minute.
I don't know, my lord.
1 minute. Why didn't you address the court instead of quarreling?
Yes, sorry, madam.
If you want to do it, go outside and do it. Yes.
Yes, page 23, madam. Serial number 3. What is the reason for not calling NIT for fresh settlement if period is already over?
You read serial 1.
Yes, serial 1. Lease period is over and possession of the said fishery was taken over on 26/1/24. Yes, I'm saying I'm not in possession, but it was also not in possession with any other lessee. I was the last lessee, my lord. So I have played before that. Before expiry, I have submitted representation before the government. There is a provision, my lord. And their representation has not yet been disposed of till date. And then Deputy Commissioner also mentioned in their respect, my lord.
So now you are not in position.
No, I am not in. That is of course, my lord. I am not in position.
Then-
Already position has been taken over from me. Now, page 23, clause 3 may be kindly seen. A petition filed under method so and so, so and so, so and so, praying for extension of lease of the state fishery has forwarded this office by letter number. So there is Deputy Commissioner says. So, my lord, I pray for some, my lord, either my representative dispose of, my lord, prior to settlement of next leasing. That is
Where's the NIT?
NIT is the next annexure, my lord. They may process the NIT, but before giving settlement, my representative may be disposed of, my lord. That is my prayer. (25/3/25) is the last date to receive the NI, my lord, tender.
You submit your tender.
No, that is on different aspect, my lord. My representative may dispose of, my lord, till, my lord, completion of settlement period, my lord. Sorry, settlement of the fishery, my lord. NIT may be gone. I'm not disturbing it, my lord. Till, my lord, the settlement has been given to settlement holder. My representative may dispose of, my lord.
NIT will be opened the same day, isn't it? Yes, as per the NIT, it will be opened on the same day.
Not sure.
Then
My lord, it is already submitted 1 year. Just 2-3 days are left. They may dispose of it, of, my lord. Direction may be given to dispose of the same, my lord. Or for 1 week or 2 weeks, maybe the NIT may be
25/3 on
stay.
25/3, that is what?
Yes, today is 21.
That is Tuesday.
Tuesday, lord.
Within Monday.
So you dispose it of by Monday?
By Monday, my lord.
That's all.
We can dispose it of. The
Yes.
representation can be disposed of.
Where's your representation?
Yes, that is at page 21.
Okay, heard Mr. B. Sinal, learned counsel for the petition. Also heard Mr. P. Sharma, learned standing counsel fisheries. For the respondents, 1.
All the respondents, I think.
1.
Circle officer is not a fishery department. 1 and 4. And Mr. M. Chitial and the government advocate for the respondents. 2 and 3. Stop. Stop. By an order dated 27 September 2016, issued by the Secretary to the Government of Assam, Fishery Department. The number 64 Barhuba Bell Fishery of Barpeta was settled with the petitioners, isn't it?
Yes, sir.
What
Society of the petitioner.
was settled with the petitioner society for a period of
7 years.
7 years. Stop. It is the case of the petitioners that the actual position of the said fishery
Yes.
was
From 26/1/2017.
was met with effect from 26/1/2020
2017.
2017. Stop. No. So in the intervening period, the COVID-19 pandemic
Yes.
set in. And also there was encroachment on the set number 64 Barhuba Bell Fishery of Barpeta. Stop. As the petitioners society suffered heavy loss during the said period, a representation was made before the joint secretary.
Yes, joint secretary.
Joint secretary, fishery department
11/12/23.
on 11/12/2023.
23.
Is not there, Lord.
No, it is there, but date is not there.
That is not there.
It is there. 20.
Who is that?
11/12/23.
It's not
এই তো আপনি পাবো ইয়াতে পাবো এইখানে 11/12
there.
23 to 9
Then how can he know?
11. I am the petitioner, my lord. He is objecting this one is
No,
not
no,
there.
this is the official record, Lord. There is no date.
11/12 is there.
What is there here, Lord?
The next is 23, 2023.
How can?
No, actually, how do we know that this was made on 20?
This is the date, my lord. I know, man. I am the petitioner, and subsequently also I have filed
If there
representation.
is any representation, we can dispose it, Lordship. Not
Praying for extension of lease period of the said 64 number Barhuba Bell Fishery of Barpeta district. Stop. Where's the report?
Report is Annexure 3, man. Page 19.
The assistant fishery officer Barpeta also submitted the report on 15/6/2024 before the circle officer, Sartipari Revenue Circle, Sartipari, reporting that 110 bika are found under encroachment of the said Barhuba Bell. Stop. The grievance of the petitioner before this court is that without considering the representation made by the petition, tender notice was issued on 4/3/2025 by the Deputy Commissioner Barpeta for settlement of the lease period of 64 number Barhuba Bell Fishery. But considering that the representation made by the petitioner on 11/12/2023 before the Joint Secretary, Fishery Department, State of Assam, is yet to be considered and disposed of, this petition is disposed of, directing the Who's the joint secretary? Is he a party here?
The secretary is major party, commissioner and secretary.
Then
Then we are the additional chief secretary is the all in all boss. Then
Commissioner is major party, my lord.
commissioner,
He has invited the tender.
commissioner has not invited us then. The deputy commissioner has invited us.
Yeah, deputy commissioner is invited.
Commissioner has not invited, never invited tender.
Commissioner and secretary, my lord, they're the same.
that is not addressed to him. Okay, directing the joint secretary.
Yes, my lord.
The joint secretary is also not the party lords.
Yeah, that is the thing. Anyway,
Directing fishery department lords. Lordship can address fishery department.
directing the authorities in the fisheries department to consider and dispose of the representation dated 11/12/2023 made by the petitioner on or before 24th.
It is a minor problem, lordship, technical problem, lordship. Lordship here, if we go for Monday, lordship, in department lordship, it will go for approval, it will take minimum 7 days. Lordship can do one thing, lordship. Because this NIT will be taken by the deputy commissioner. While they used to send us the document, it will take 1 month. So lordship can observe that we can, before settling, we can dispose of the application.
Dispose of the representation made by the petitioner before the settlement of the
64 Borgofa.
64 of the 64 number Barkova Bell Fishery under Sativari Revenue Circle in terms of the tender notice dated 4/3/2022.
Lordship, one observation, lordship, from my clarity, lordship, that tender notice is not interfered. Can go ahead.
It is made clear that this court is not interfering with the tender notice dated 4/3/2020.
It may go ahead. Highly obliged.
I said it is made clear that this court is not interfering with the tender notice.
Yes, lordship, that is.
Obliged.
Highly obliged.
I'm sorry, I'm very sorry, my lord, for this.
20,
May it please your lordship.
Same order,
Same order.
just give the village name, the voter list.
Your lordship, her grandfather name was enlisted, 2005, your lordship.
Where,
After
where?
her marriage, your lordship, annexure 8, your lordship. It pays 31, your lordship will find. Bhavanipur LSE, your lordship. 41 Bhavanipur LSE, your lordship.
What's the list? 2005. LSC will be 41 number Bhavanipur.
Your lordship.
Village Holongbari, madam.
Huh?
Village Holongbari.
Where is that?
Page 32.
Page 32.
Your lordship in vernacular, your lordship.
You have not typed in into the.
Your lordship, yeah, that is my mistake, your lordship. That village name I have not been, it has not been typed, your lordship.
Village.
Holongbari.
Holongbari.
Have you mentioned it somewhere in the writ petition? You know,
Your lordship is not been specifically, however, it
Page
is
7, your lordship.
page 7, your lordship.
Page 7,
Paragraph
paragraph
6.
Village Holongbari, your lordship.
Holongbari, village Holongbari. It's PS
Atachar Kusi, your lordship.
police station.
Atachar Kusi, your lordship.
Where is that?
They're in the same paragraph, your lordship. Page 7, your lordship, paragraph 6.
Okay, PS. Patachar Kuchi. That's all?
Yes. SP border Borpetoman.
It will be respondent number 6. SP border. It will be not Golbara, but Barpeta.
Oblige your lordship.
21.
My lord, the matter pertains to my lord non-payment of supply order in refreshment of COVID center at Hailagandhi, my lord, amounting to rupees 6,65,000. Lordship may kindly come to page 21 first, my lord. This is the supply order, my lord.
Okay, heard Mr.
Yes, Choudhury.
Chowdhury, learned counsel for petition. By this petition is claiming for payment of outstanding dues amounting to rupees 6,65,300. Issue notice. MS D.
D. Bora.
D. Bora. No.
Standing Council Health Department.
Standing Council Health Department appears for respondents 1,
1, 2, 4,
2, 4,
6 and 8.
6 and 8. And how about 5?
Additional district.
And Mr. M. Chitial and the government advocate enters appearance on behalf of respondents 3, 5 and 7. 5 and 7. Notice on respondents are complete, however, extra copies. Respondents are allowed to file a list of holdings.
Extra copies to be.
That's what happened.
Monday, madam.
Okay.
22.
May I be your lordship? Lordship, the petitioner herein is a firm. It was initially a proprietorship firm in the name of Biswajit Borua. It had a particular vendor code 101000950. Now, lordship, a work order was issued on 25/7/2020 under the same vendor code. Lordship, the works were being continued, and in the meantime, Biswajit Borua was unwell. So he entered into a partnership deed with his two sons. Thereafter, another work order was issued, that is Annexure 4, that was dated 6/7/2021.
Page.
Yes, Lordship. Lordship will first take up the Annexure 1 that your Lordship will find at page 42. Lordship, I will refer to the original copies because everything had to be typed. Lordship will turn to page 47. This is the first work order which was issued when it was run by Mr. Biswajit Borua as a proprietor.
Okay.
Lordship will see in the first column vendor ID, vendor number, that is 101000950. Now, Lordship, while executing this work, he was unwell. That is why he entered into a partnership deed in respect of the same firm with his sons. That your Lordship will find at page 55, the original.
Okay.
Then, Lordship, after the partnership firm was entered into, Lordship, another work order was
Sons are major.
Lordship, sons are major, Lordship. Sons are major. Now, Lordship will turn to Annexure 3, that is page 60. The original your Lordship will find at page 66. Sorry, Lordship, 67. Lordship will note the vendor code is the same, 101000950.
Okay.
And the work order is 271-26726 on the right side of the column. While these works were being executed, Lordship, the said person expired. Lordship will find his death certificate at page 86. He died on 27/11/2021. We're given a type copy, Lordship. These are very illegible.
Okay.
Then Lordship will turn to page 89. These are his legal heirs. Geeta Borua is the wife, Mohit Borua, the son, and Mrityunjay Borua, son. Page 89, Lordship. So now, Lordship, in terms of the earlier partnership, there was a clause that in case of the death of any of the partner, they may incorporate the legal heir of the partner who has expired. Now his mother was entered into as another partner in the partnership firm.
Mother of the
Sons, the wife of the deceased person.
That's Gita Baro.
Gita Barwa. Yes, Lordship. Lordship will just turn to page 101 for a minute. Lordship, the second pair I will read. And whereas the partners hereto after deliberation and discussions decided to associate themselves to run the contract works of the existing partnership firm with a view to earning profit and so and so. Now your Lordship will come to the relevant page at page 129. Lordship, after this was done, the petitioners, the Gita Borua, the wife of the deceased person, makes an application to the Deputy General Manager. I'm reading to the original one, Lordship. I'm not going to the type portions. Lordship will see towards the bottom of that page, there is a note. In view of the recent legal opinion obtained from page 129. It's very small, Lordship. I will read it. In view of the recent legal opinion obtained from RHQ Legal, may kindly do the needful for creation of a new vendor code and for inclusion of the new vendor code for the old contracts / new contracts with this vendor code for balance execution of the contracts. So, Lordship, the earlier vendor code, they say you issue a new vendor code now. And the earlier works and the new works will be done under the new vendor code. Now, Lordship, while the works were being executed, another tender came. The work order is at page 130, 140, Lordship. Now, your Lordship will see the vendor code. This is the new vendor code at page 140 on the left side. 132765777. Name of the firm is the same, Biswajit Borwa. While this work order was issued on 18/4/2023. While these works were being executed, Lordship, on 18/1/2024, they stopped us from working and refused to make any payments. So a legal notice was sent, which your Lordship will find at page 165. Here it was specifically stated that you are not allowing us to work verbally. 165, Lordship. Now, Lordship, once this notice was received by them on 18/1, they sent a show cause for holiday listing. Holiday listing is when you put a vendor for blacklisting. If your Lordship will turn to that page 172, it starts. Lordship, I will read the relevant portions. These two work orders are referred here in the show cause notice are Annexures 1 and Annexure 4. Because in the meantime, Lordship, these earlier work orders were renumbered under the new vendor code. Now, Lordship, what they say is that during the execution of work order 26506055, that is Annexure 13. This was the new work order which was issued. That was dated 12/7/2023. They say you have entered into partnership without taking prior approval from IOCL, which is in violation of GCC, and subsequently also participate in the capacity of a proprietor firm under pen number so-and-so against tender number so-and-so dated 27/5/21 with date submission and date so-and-so, emerged as successful bidder and was awarded the work order so-and-so. You are hereby required to show cause in writing within 15 days from the date hereof why you should not be placed on holiday list and be debarred from entering into contract with IOCL, be not delisted from the list of approved vendor contractors of Indian Oil Corporation for the following reasons. Now, the reasons which they have given for show cause are: has submitted fake, false, fabricated or forged document certificates, has violated, circumvented the provisions of law, including labor law, regulation, rules, safety, environmental norms, or other statutory requirements, has committed breach of contract, any other ground which in the opinion of the corporation makes it undesirable to deal with the party.
What
We-
is the date of this show cause?
This show cause was dated, Lordship, 18/1/2024. Lordship will find the date in page 174. Very faintly given, 18/1/2024 on the top side. We replied to the show cause saying that we had not submitted any false, fake or fabricated documents. Thereafter, they issue us a show cause notice for termination. Now, this show cause notice for termination has been issued under clause 4.10.0.0 that I have annexed, Lordship. And Lordship, we filed a reply saying that we have narrated the entire facts of event, how they happened, how the vendor codes were changed, how we were asked to work under the new vendor code. Now, without taking into consideration this reply, they have issued us a termination. The termination has been issued under clause 7.0.0 that your Lordship will find at page 185. The termination was issued in respect of the annexure 13, that is the work order dated 12/7/2023. Now, Lordship, if I take your Lordship to the relevant clauses, your Lordship will find I have extracted the relevant clauses as page 187.
Yes.
Lordship, 4.10.0.0 down below, change in the constitution of the contractor. The contractor, whether an individual proprietary concerned partnership firm, private limited company or private public limited company shall not make any changes in constitution by transfer of substantial shareholding or of the management in case of a company or by addition or deletion of partners, changes in the terms of partnership or make any material changes without prior intimation to an approval of the owner. As such, unauthorized changes shall attract the provisions of clause 7.0.1.0. So what does 7.1.0 say? Lordship will turn to the next page at page 188. Lordship, these are the various reasons on which a termination can take place. Now, Lordship will read clause 4 down below. If there is a change in the constitution of the contractor, if a firm or in the circumstances of the organization of the contractor, which is detrimental to the interest of the work or of the owner. So if my change in the partnership is detrimental to the interest of the owner is the IOCL, then they can cancel it. Now, Lordship, they have relied upon clause 11 on the next page. The occurrence of any other act, event, misfeasance, malfeasance, or omission in respect of which the contract document or any declaration furnished in terms hereof or pursuant thereto provides for termination of contract. Now, Lordship, their allegation is that we have participated in the fresh tender using the documents of the earlier vendor code.
Exactly.
Now, Lordship, the vendor code, they have allowed us to change the vendor code. They have said you cannot use the earlier vendor code. You have to adhere to the new vendor code. And the works which we have given, the work orders, they have been renumbered. And we are allowed to continue the earlier works in terms of the new vendor code now. So, Lordship, where is the part on, where is the act on my part which calls for misfeasance, maleficence, or omission in respect of any document submitted? So, Lordship, what I'm praying for at this stage, your Lordship may issue notice in the matter. Lordship, we have made a specific statement that the work which was allotted to us by the annexure 13, that has not been handed over to anyone till date, nor has any tender been issued. Lordship will protect me to that part. That the work should not
This
be
is a
protected.
termination of 8/8/2024.
Lordship, the work order is of 12/7/2023, which has been cancelled.
That is fine.
Yes, the work order is of 8/8. We have made a specific and categorical statement, Lordship, that the work has not been allotted to anyone till date.
We'll have to see what the affidavit says.
The matter has come up for the first time today. And Lordship has already pointed out, it's an order of 8/8/2024. No explanation as to why they are now coming in the month of March. Already terminated.
Okay, we have
Notice
given-
be issued. Let the notice be issued. I'll file my-
Mr.
MDAS. Lordship will just give me a minute, Lordship. Lordship, if the work as on date is pending, Lordship will just protect me to that extent. If it has not been given to anyone,
This
then
is
let
all-
it remain as it is.
This is all.
If it has been
repairing
given to
work.
anyone, I have
My
nothing to say.
inspection is, it has been already been done.
Okay, heard Mr. M. Das, let me counsel for the petitioner. Issue notice. Mr.
And A. Sharma, Lordship.
A. Sharma,
For all the respondents.
standing counsel.
Standing counsel IOCL.
IOCL enters appearance and reads of notice on behalf of all
All the
all
respondents.
the respondents. Huh? Notice on respondents are complete, however, extra copies. Respondents are allowed to file the list after 4 weeks.
Yes, your last four.
Can I ask for a shorter date, Lordship? Because the only problem is if the work is now given to someone, then my repetition becomes infructuous, Lordship.
This work has already been done. That's my
Because
instruction.
Lordship, that is not on record now as of right now.
Another instructions that I have, but he has not annexed the tender document. There is an arbitration clause.
Lordship, the arbitration clause
is.
is not applicable. Why, if I may read, Lordship, I can read that. Lordship,
That is
that
also
relates
another
only to the final bills. If I may read the arbitration clause, subjected to provisions of clause 6.7.1.0, 6.7.2.0, and 9.0.2.0, any disputing arising out of a notified claim of the contractor included in the final bill of the contractor in accordance with the provision of clause 6.6.3.0 hereof, and any disputing arising out of any claims of the owner against the
3
contractor
weeks.
shall refer to arbitration.
3 weeks.
3 weeks.
Oblige.
Lordship may just indicate if Lordship may also issue notice on the interim, Lordship, at this stage. Only issue a notice on
What
the interim.
interim do you want? What
Lordship,
interim do you
because
want?
if the work has not been allotted to anyone,
What he's saying is under
because
instructions.
the work,
just been
work
given out.
order
I'll
given
file
to
my
me
affidavit everybody clear, Lordship, in that.
Okay.
was valid till 20.
Okay, prayer for
40
interim
years.
shall be considered.
Oblige.
Oblige.
23, 24, 44 to 51.
What is that? Contractual bill matters.
What's the second point?
40.
These motions are also same tender, same thing, but only the items is different. There is vegetable, here is paddy, but the same tender, everything is same. So it is similar to 44 to 51.
Lordship, my instruction has been given.
Where was that instruction that you have given
In
us?
item number 44, earlier I have submitted. Lordship. Communication dated 17th March 2025. Lordship.
17th of March.
17 March, 13 March, and there is a lease. Lordship.
This was not the document, if one document was there which indicate that so and so amount has been.
Lordship, in the budget report, expenditure budget report.
There was a document which you have produced the other day, that so and so amount has been placed for the clearing liabilities.
17 March 2000.
Okay, yes, correct, yeah, it's it. Yes.
Lordship, now it is admitted amount. So this will do, Lordship.
Is an admitted amount?
Lordship.
Okay. What is item 23, is it?
Yes, Lordship.
1594.
Lordship, 23 and 24 are new items.
New item today coming for motion, but
So
Lordship,
you want this disposed or on the same line?
We dispose of Lordship in the same, as all the pending liabilities are amount to category under
Lordship may
the.
pass order in 44 to 51 and this will cover these motions also.
That will-
No, all these are separate items, isn't it?
Separate items, but
So separate orders.
separate orders, Lordship. So Lordship, as per
These orders are, therefore they have given individually for each case.
we have given to the court.
Your Lordship also, he has also got a copy. So that can be verified and the number of petitions which are pending, my lord, it corresponds to that. they have two new petitions today. That is also mentioned here in this bunch.
Yeah.
Okay, some are seats, some are all seats.
Seats. Only today's two matters are petty. Motions.
So motion also we can dispose of.
Yes, yes.
These two motions are going to be, this is a fresh motion today. Others are already pending and
It is an,
I think you have covered all the new ones also.
yes, yes.
Okay, heard Mr. B.K. Goswami, learned senior counsel, assisted by Mr. B.B. Bora, learned counsel for the petitioner. Stop. Also heard MS
Zibora.
Zibora, learned standing counsel, agriculture. For the respondents, 1, 3, 4,
1, 3 and 5, Lordship.
1, 3 and
5.
5. Assam Seeds Corporation Limited, finance.
Finance.
Mr. B. Gogoi, learned standing counsel, finance for the respondent number 2. Are the respondents all the same in the writ petition or there are some variation?
No, same. Same
Are you sure?
respondent. Lordship, 44 to 51 are the same, Lordship. I'll just check 23 and 24. It is the same, Lordship. I'll just check. It's the same.
Regarding disposal, that will be difficult without having an inspection. Because if they are admitting, there will be financial liability. I will have to take the inspection.
No.
In the first two items.
In fact, similar cases are also pending as in this one. We don't have that. Yes. I will have to take inspection. Let it be in a motion state. In fact,
These two items.
Yes, sir.
And the other admission matters.
Without instruction, it will be difficult. Heavy liability.
There was an understanding the other day that this will be disposed of today in view of the instructions, written instructions received by the Standing Council Agriculture Department.
Yes, but this Khan brothers, let it come along with this cases, Khan brothers. Those
What?
are pending as.
Khan brothers are here.
They did, let it come along with this one.
No, Khan brothers is also here.
Today.
Where's the Khan brothers?
Item 46. 46.
Oh, Khan brothers is there.
It is last order to finance or not?
Last order to finance or to?
Finance.
What is concerned? No, it will be more.
Okay, what I'll do, Gogoi, I'll give a very short time. Because I clearly remember
Yes,
it
but
was
I
it was
saying,
it was day before yesterday that there was an understanding it will be disposed of today in terms of the instructions received by the Agriculture Department.
Yes.
Well, ultimately, the liability will be on the finance department. They will just say that this is the communication, this is the liability. Then they will submit.
Can you read the communication of 17th March?
Read. What it is.
It has been already allocated.
I remember, my lord, because there is another series, my lord, of Khan brothers, my lord, this is the petitioner. Where, my lord, we have been directed to have the inspection. We have communicated, my lord, these are communication. My lord. Let it be on, my lord, Monday, I will have the inspection. Monday, no, Wednesday, my lord. Going on holiday. Wednesday. We have communicated.
The last order to car affiliate. You did digitalize only
Okay.
of which code for.
Heard so and so, huh? Heard Mr. Goswami, learned senior
No, there is a.
assistant
I
by
have
Mr.
not
B.B.
seen.
Bora, learned
Last
counsel for
time
the
when you
petition.
filed, court is saying that there is.
Issue notice.
Already located.
MSG for learned standing council agriculture appears for respondents 1, 3, and 5. And Mr. B. Google, learned standing council. Finance
You have
department,
already allotted
appears
what
for the
I'm saying
respondent
now.
number 2. Oh,
Sorry?
okay. Mr. B. Google prays for 1 day time to enable him to receive instructions. Learned standing council finance, no? Praise the Lord. Please on Monday or Tuesday?
Tuesday, my lord. Just one short verification I will have.
On 25th, along with WBC number
3903 of 2023. 46.
Along with the motions.
Along with, I'm passing order in the motion. Along with WBC 3903 oblique 2022. And then in the other writ petition.
So I can
Tuesday আমার এখানে নেওয়া আছে।
কোনটো?
All these instructions in the respective file and they
Last time you could not decide that amount to the nine.
and in the other writ petition 1596. Same two more. G Bora, standing council agree for 1, 3 and
No, are you
Five.
disputing?
No,
Are you
not-
disputing
that
that
I will not.
Big over.
amount was allotted?
then a standing council finance for the phone number 2.
No, no, if you are not
On
disputing,
request
then I
made by
don't
D
know
Google
what.
and a standing council finance department. List the matter on 25th along with WBC 390 of 2020. Okay. And in, so we are listing it on Tuesday along with the other. And then the other writ petitions. That is item 44 to 51. Just say. Heard PK Goswami, Leonard Senior Council, assisted by PK Bora. Also heard MS Swenson, Leonard Standing Council, Agriculture Department, on request made by D Gogoi, Leonard Standing Council, Finance Department, this is from 25. Because Gogoi, that 17th March 2025, that language is very clear.
But that's why only on these things.
It's already allocated. It's already allocated.
If it is allocated, then it will be deposited in the account. of the
That's what I'm saying.
Only on Tuesday, madam. But let me have the instruction. now.
Okay.
Because there are instruction placed by that it is allocated. Tomorrow they will say that the FOC is not being granted. Again, it will hang. That's why I'm saying, madam. I will have the specific instruction.
Okay.
25 motion.
Put it in all the respective.
Lordship, I think there's a caveat. You have served copies and they have appeared. So caveat may be disposed of.
Caveat is there?
Yes.
Okay. I Chowdhury is appearing.
Madam,
Third,
for
I-
ONGC,
Chowdhury,
all the responses.
Senior counsel for the caveat you have. Caveat starts discharged.
May it please your Lordship. Lordship, here I'm challenging the termination order, which is at page 109, annexure 14.
109.
Page. Yes. Annexure 14.
Yes.
Lordship, the rest, they have quoted the various what has happened. We have appointed, no, Lordship will find. Notification award number this was issued to your firm for civil and this work. We completed within 36 months from the NOA 86, that is 8/3/2025. Whereas you appointed Kevin Design Consultant, Engineering Consultant as contractor, however, during review of technical documents submitted, a drawing document submitted by you for the subject job has been found not to be in order as the signature and stamp of the drawing seem to be forged by you, by your company. The authenticity of the signature and stamp was sought from Kevin by mail dated 16/2/2024. In response, they confirmed that the mail dated this, that the signature and stamp of the document was not done by them. And whereas a mail was sent to you on 19/2/2024, citing the above issue, you responded as follows. This is in reference to your email dated this on the subject cited above. The matter has come to my knowledge and the same has been investigated by myself. In this regard, the following is clarified. On behalf of Oval Projects Engineering Private Limited, I regret and condemn the unfortunate incident at the highest level. The individual committed an error inadvertently in a rush of work pressure. Please rest assured that such lapses will not be allowed in future. In order to fully plug such lapses to reoccur in future, the DSA and Mrs. Kevin shall be kept in the loop during the all design engineering documents and approval process between OPAL and ONGC and in this project. The erring individual has been replaced by more responsible person to take better care of the responsibilities related to design engineering, coordination work with the coordination work with the ONGC and the most prestigious client, and we are serious in our business with them. On the basis of this assurance, I request ONGC to let go of this whole incident. This is what. Then, Lordship, after that, whereas it's apparent the drawing was forged by way of deceit in signature, which is forgery, and it's to be dealt with under clause 16 of the contract, read with the provisions of the integrity pact, which forms a part of the contract. Clause 16 of the contract provides as under. Now 16 is quoted, Lordship. Thereafter, Lordship will come. And whereas the show cause notice was sent to you on 14/11/2024, against which a stay order was issued by the High Court based on your writ petition. Further, the receipt of the order dated 28/1/2005 of the Honorable High Court on 3/2/2000, you have been asked to submit response to the show cause notice. You have replied by mail dated 7/2/2005. In line with the court order and based on your request for personal hearing, by mail dated this, the same was done on 28/2/2025. And whereas the competent authority in ONGC deliberated the contents of the reply to the show cause, it was observed that by the competent authority that clause 16 of the contract does not specify the type of document or its commercial implication on the reasons due to which the forgery has occurred, and so the said clause does not have any such provision for letting go of such incident. Mrs. Opal has accepted this false submission of document by mail dated 22/2/2024. Further, even after giving assurance, now Lordship will come. Now this is a new case which is being cited here. Further, even after assurance being given that such lapse will not be allowed in future, in its mail dated 22/2024, there was one more forged document submitted by Mrs. Opal pertaining to high mast, which was later confirmed by the DEC, Mrs. Kevin, by mail dated 5/5/2024, Annexure 1. Further, ONGC never accepted the explanation given by Opal against the allegations of forgery, nor did it condone the forgery by extending the time of phase 1 of the project. Further, during the personal hearing, Mrs. Opal submitted a write-up on 28/2/2025 in personal hearing, wherein it stated that Kevin confirmed the document was correct and no changes had been done in the original submission. In this regard, the company authority observed that Mrs. Kevin did not approve the same document. Instead, Kevin has submitted the document with a comment and instructed Opal to resubmitted the incorporation in the comments within 7 days. Hence, the claim of Opal is also incorrect, and observing that the inspection repair of oil stages tanks are carried out to meet mandatory statutory guidance, delay in these activities have caused loss to the ONGC. Based on the reasons mentioned in paragraph 7, and after due deliberation and in consideration of the entire records of the communication, the competent authority is satisfied that you have committed the breach of contract by providing forged drawings, and the same is accepted by Kevin and yourself by email later this and this. And so the competent authority of ONGC has decided to terminate the notification award of contract in accordance to awarded to you in accordance with clause 8.33 led with clause 16 of the General Clauses Act and violation of the integrity pact of the tender document. Now, this is what a tender document. In the circumstances, you are hereby informed that the reason stated herein before the notification of award dated this, contract being this, awarded to you is hereby terminated with immediate effect, and security deposit SD submitted by you shall be forfeited in accordance with clause 8.33 read with clause 16 of the contract. Further, due to termination of the notification award dated this on account of submission of forged documents in accordance with clause 8.33 of the we read with clause 16 and violation of integrity pact, you are liable to consequential actions as per contract conditions. Now, this is the termination order. Now, Lordship will look at the show cause notice, which has been issued to us, Lordship. Then they say at page 110, further, even after giving assurance that such lapses will not be allowed in future, in the mail dated this, there was one more forged document submitted by you at paragraph 7.70. Forged document submitted by Opal pertaining to high mast, and that was later confirmed by Kevin in the mail dated this. Further, ONDC, this is one more aspect which they have taken into consideration. And then they say that Kevin, in regard to the company, observed that Kevin has not approved the same document. Instead, Kevin submitted the document with a comment and instructed Opal to resubmit the incorporate within 7 days. The claim of Opal is incorrect. Then, Lordship will come to paragraph 9. And there's one more fact they added here is that otherwise, observing that the inspection report of repair of oil storage tanks are carried out to meet mandatory statutory guidelines, delay in these activities has caused loss to ONGC. Now, high mast, loss to ONGC, these are, and the first document, these 3 grounds, and then they add one more, Lordship. They say that at paragraph 9 point, so the competent authority decided that termination of the notification award of contract in accordance with clause 8.33 read with clause 16 of the general conditions of contract and violation of integrity pact. These are the reasons I have been terminated. Now, Lordship will look at the show cause notice, which is at page 73. Annexure 10, page 73. In this connection, Lordship will find, please refer to the contract number this. In connection, you appointed Messrs. Kevin and as design engineering consultant.
You have a typed copy.
You have a typed copy? No, Lordship, I do not have.
Okay, anyway, let me try to read it. It was not readable.
You do have a typed copy?
In fact, with greatest respect, the copy that has been served on us, the half of the pages are not readable. So I have made my preparations on hypothesis, conjectures, and summation.
Okay, do we have one more set? We have one more set. Huh? Lordship, mine is legible. Can I just forward it?
Okay, read it.
I'll read it. In this connection, you appointed Mrs. Kevin as design engineering consultant for the contract. In this however, during the review of technical documents submission of drawing document and submitted by you for the subject job has been found not in order as signature and stamp on the drawing seems to be forged by your company. The authenticity of the signature and stamp was signed from Messrs. Kevin by mail dated this. In response, they confirmed by mail dated 16/2/2024 that the sign and stamp of the document were not done by them. Copy of the aforesaid mail dated 16/2/2024 received from Kevin is annexed herewith. In this regard, a mail was sent to you on 19/2/2024 citing the above issues. You have responded as follows, quote, this is in reference to your email dated this on the subject cited above. The matter come to my knowledge and the same has been investigated by myself. In this regard, the following is clarified. On behalf of Oval Project Engineering Private Limited, I regret and condemn the unfortunate incident with the highest level. The incident has been committed, the individual has committed the error inadvertently and in a rush of work pressure. Please rest assured that such lapse will not be allowed in future. In order to fully plug such lapses to reoccur in future, the DEC, Mrs. Kevin, shall be kept in the loop during all design engineering documents approval process between Opal and ONGC on the project. The erring individual has been replaced with more responsible person to keep better care of the to take better care of the responsibilities related to the design engineering coordination work with the client. ONGC is our most prestigious client and we are serious in our business with them. On the basis of this assurance, I request the ONGC to let go of this sole incident. Then, Lordship, thus in view of the above, it is apparent that the drawing was forged by you by deceit in sign, which is a forgery and is dealt with under clause 16 of the contract read with provisions of the integrity pact, which forms a part of this contract. Now they say this. Then Lordship clause 16 is quoted. In view of the above, you have violated clause 16 of the contract and violated the provisions of the integrity pact. Hence, as per our company policy, you are hereby being informed that an opportunity is being provided to you to submit your response within 14 days as to why ONGC should not terminate the contract and invoke the PBG as per clause 16 of the general conditions of contract pertaining to the authenticity of the document and suspend business dealings with you, that is, Oval Projects for violation of the integrity pact. Now, this is what has been given to us. Now, Lordship, what has happened is that in that the high mass factor has not been mentioned. How the integrity pact has been violated, that has not been mentioned. Nothing. You violated, that's all. Now, Lordship will look at the integrity pact. The integrity pact is at 122. Now, Lordship, that is section 1 is the commitment of the principal. Section 2 is the commitments of the bidder. And that's at page 124. The bidder contractor commits itself to take all measures necessary to prevent corruption. Page 124, to prevent corruption. He commits himself to observe the following principles during the participation in the tender process and during contract execution. The bidder will not directly or through any other person or firm otherwise promise or give to any other principal's employees involved in the tendering process or execution of the contract, or any third person, any material or immaterial benefit which he is actually not legally entitled to, in order to obtain in exchange any advance of any kind whatsoever during the tender process or during the execution of the tender. Now, this the show cause notice doesn't say anything what I've done. Then the bidder contractor will not enter into other bids enter with other bidders into any undisclosed agreement or understanding, whether formal or informal. This applies in particular to the prices, specification, uh, certifications, subsidiary contracts, submission or non-submission of bids or any other actions, or to restrict competitiveness or introduce cartelization of the bidding process. This allegation is also not there. The bidder will not commit any offense under the relevant anti-corruption laws of India. Further, the bidder will not use improperly or for the purpose of competition or any personal gain, or pass on any other information or documents provided by the principal as a part of this business relationship regarding the plan's technical proposal, business details, including information or transmitted, contained or transmitted electronically. This allegation is also not there, Lordship. The bidder will not when presenting his bids, disclose any or all payments he has made is committed to or intends to make to agents, brokers, or any other intermediaries in connection with or any award with the award of the contract. This allegation is also not there. Bidder will not instigate third persons to commit offense outlined above or to be accessories to such offenses. Now, these other offenses, none of the allegations are there in the show cause notice. And the allegation regarding the high mast, that also not there. Now, in the termination order, these new factors have come in. The question which arises, can the termination order go beyond what is there in the show cause notice? On this ground itself, the termination order has to go, because it has traveled beyond the show cause notice. Show cause notice doesn't talk about high marks, doesn't talk about what is the provision of the integrity pact which I violated. May just mentioning that you have violated integrity pact is not enough. What have I committed any of the offenses laid out there? No, Lordship, in my respectful submission. No. Lordship, the number of Supreme Court judges' decisions which have said that one cannot go beyond the termination order, cannot go beyond the show cause notice. And this is a clear case where the termination order goes beyond the show cause notice, takes into considerations other aspects, because it's very clear. Also considering that you have given another forged document on 15/4/2024 regarding the high mast. That was never there in the show cause notice. I would have responded, I would have shown my cause against that. Which is this?
Cannot go beyond.
Yeah, like 2025 SCC online, page 3, have given online 343. Lordship, at paragraph 32, it's written, the final order in any case cannot travel beyond the show cause notice. It is very clear. Here is a case, it's gone beyond. And it is it just mentions high mass is not there, integrity pact is just mentioned, not says what provisions. Even if I had submitted a document which was forged, does it still fall under the provisions which is laid down in the integrity pact?
Yeah, referring to which para?
Para 32, Lordship. Para 32, I just. There's a line there. This is on blacklisting, but nevertheless, this will apply. Para 32, to take an instant case, the show cause notice in the present case is the final order of blacklisting. The final order in any case cannot go beyond the show cause notice. So it has to be confined to the show cause notice. There's another one. Lordship, there's one more, 2011, 1 SCC. Paragraph 19, have you good? Huh? 2011, 1 SCC, page 109. Not Gurkha, Commissioner of Central Excess. Gurkha also says the same thing. Page 19, paragraph 19. Lordship, it says it's a trite law that unless the foundation of the case is laid in the show cause notice, the revenue cannot be permitted to build up a new case against the SSC. Right. Lordship, there are a number of cases which is there. The fact, because I must know what I have to defend against. Now, in the final order, I mean, the termination order, they bring up new allegations and they just put in the word of integrity pact without there being any foundation as to how. In this view of the matter, I'm praying that I'm challenging the termination order. And of course, I'm praying for stay in the interim stay.
Yes. My lord has noted the date of the order of termination, 13/3, with immediate effect, which means it has already taken effect. And consequences thereafter have also, consequential orders have also been issued. So my first submission is, your lordship will certainly examine since it's a termination matter. This is no, it cannot be a question of.
What consequential orders?
Because the contract, that is the other sad part one. The contract and the relevant clauses have not even been annexed. I'll place it. The contract provides that if you resort to these kinds of acts, submitting forged documents, etc., your contract can be terminated. And as a consequence of termination, one of the first consequences is suspension of business dealing with the party. That order has already been issued. We have encashed the security deposit in the form of a bank guarantee. That has also taken place. And there are further consequences provided. We can even go to the extent of blacklisting after issuing show cause. The facts are like this, man. Here's a contract that was awarded to the petitioner. They are required to engage a consultant for approving the drawings, designs, etc. Now, the contract itself again provides that once these documents are submitted to us, the drawings, designs, etc., we can verify internally. In one such instance, when these drawings and designs, etc., were submitted to us, we found that there is something wrong. So we wrote to the consultant. The consultant says that we have never approved this, and this sign and signature is not ours. Seal and signature is not ours. So we sent an email to the petitioner. The petitioner, I'll place those documents. The petitioner admits that yes, we have committed this forgery. The word forgery is not used, but the petitioner admits. Based on that, although it was on admission, your lordship is aware, we are not even required because we could have simply said that it will be a useless formality since you have already admitted. But we still issued a show cause notice. And thereafter, that show cause notice was challenged. Initially, there was an ex parte interim order. We filed an application for vacation. The interim order was vacated. Thereafter, we proceeded.
Where's that order?
That order, your lordship will find
28-1. The original interim order was at page, is at page 76. Page 76 is the interim order. Operative portion is at page 78. Till the returnable date, further proceedings pursuant to the show cause notice dated so and so shall be kept in abeyance. Thereafter, my lord, we file an application for vacation, which starts at page 79. It's a very long order because all aspects were gone into. Your lordship will find the operative portion at page 92. Paragraph 22 onwards. This court is also of the view that if the noticee asks for an opportunity of personal hearing, the same shall be provided to the noticee. The instant interlocutory application stands accordingly allowed to the extent indicated above. Insofar as the other issue regarding maintainability of the writ petition for not impleading the ONGC, which is the instrumentality of the state as a party respondent in the writ petition, is kept open for consideration at an appropriate stage for the fact that in the meantime an interlocutory application has been preferred by the opposite party petitioner seeking impleadment of ONGC, etc. At this stage, Mrs. So-and-so, learned senior counsel appearing for the opposite party, writ petitioner has submitted that the opposite party writ petitioner be granted the liberty to respond to the show cause notice in writing within 14 days from today. Having regard to the reasonableness of the prayer so made, such liberty is granted. In view of the discussions made above and the reasons assigned therein, I am of the considered view that the interim order passed on so-and-so needs to be vacated. Accordingly, the interim order stands. Now, after this, we proceeded to decide on the show cause notice. We gave the petitioner a personal hearing also, as indicated by this honorable court. And after all that, we have terminated. And if your lordship will kindly come to the first response, we issued, your lordship will kindly turn to page 48 first. This is the email we sent to, as soon as we detected that there is something wrong, we immediately sent an email to the petitioner. Page 48. This has reference to your trailing mail dated 13/2/24 submitting the approved technical data sheet of instrumentation cable for review by the ONGC. As part of our internal process, we had sought the confirmation from Messrs. Kevin Engineering and so on the authenticity of its approval of the referred documents as stamped in the same. Kevin is that consultant one. In response to the above, Messrs. Kevin has informed us as follows. We did not receive the attached technical data sheet.
Page 42.
Page 48, man.
Oh.
I'm sorry. Page 48, annexure 2. This has reference to your trailing mail dated so-and-so submitting the approved technical data sheet of instrumentation cable for review by ONGC. As part of our internal process, we had sought the confirmation of Messrs. Kevin on the authenticity of its approval of the referred documents as stamped in the same. In response to the above, Messrs. Kevin has informed us as follows. We did not receive the attached technical data sheet or instrumentation cable document from Messrs. Oval. Oval is the petitioner, and not approved by Messrs. Kevin. The sign and stamp in the attached document are not done by us. Your lordship will kindly note this one. Screenshot of the mail is attached for your reference. In view of the above, your response explaining the so-and-so reported discrepancy is required within a period of 3 working days. And to this, the response your lordship will find at page 51. I'm sorry. Page 51.
Yeah.
This has reference to your mail dated 19/2/24 on the subject cited above. The matter has come to my knowledge and the same has been investigated by myself. In this regard, the following is clarified. On behalf of Oval Projects, I regret and condemn the unfortunate incident at the highest level. So, first sentence itself is an admission. The individual has committed the error inadvertently in a rush of work pressure. Pausing here for a moment, Manoj. How can rush of work pressure lead to forgery? There might be work pressure. Does that mean that I'll go and commit forgery? Next one. Please rest assured that such lapses will not be allowed in future.
In order to fully plug such lapses to reoccur in future, the so-and-so Kevin shall be kept in the loop during all design engineering documents approval process between OPEL and ONGC on this project. The erring individual has been replaced with more responsible person to take better care of responsibilities related to the design engineering coordination work with the client. ONGC is our most prestigious client and we are serious in our business with them. On the basis of this assurance, your lordship will kindly note this one. I request ONGC to let go of this sole incident as one-time error. The petitioner was all along aware of the consequences of such forgery. And therefore, he makes a request that please forgive us this time. But the problem is, my lord, if your lordship will kindly take the agreement. The contract itself, what it provides. Yeah, no? Huh? Huh. Clause 16. Oh, more copy to total copy to copy. Your lordship may come to, we have just given some of the relevant portions. It's a very bulky document. The whole tender contract agreement runs into almost 100 pages, maybe even more. Your lordship will perhaps find clause 16 at the last page of that bunch. The internal page is 104. Has my lord got it? Clause 16. Authenticity of all documents, certificates, information submitted by the bidder against the tender. Contractor should note that ONGC may verify authenticity of all documents, certificates, information submitted by the contractor or contractor as bidder against the contract or tender. In case at any stage of tendering process or contract execution, etc., if it is established that the contractor or contractor as a bidder has submitted false documents, certificates, information towards fulfillment or any of the tender contract conditions, ONGC shall immediately reject the bid of such bidder or cancel, terminate the contract and forfeit as the submitted by the contract. So this clause makes it mandatory for terminating the contract and forfeiting the security deposit. So therefore, we proceeded, we were as fair as required under the law. We gave him a show cause notice, followed it up with a personal hearing. And what has been pointed out by my learned friend, that another forgery is referred to. That is not the reason for the termination. The reason for the termination is the first forgery. Why we refer to that is, if your lordship sees, goes back to that email, they have given repeated assurances that this will never happen in future. But in spite of that, in respect of another document, they committed a forgery again. It is in passing reference that we refer to that. Otherwise, the reason for the termination is the first forgery. So therefore,
that is not clear in your termination order.
It is not expressly noted. But what we have said, if your lordship kindly comes to the order of termination, page 109. If your lordship kindly first comes to 109, that portion of the email where they admit is a verbatim quoted at para 3 down below. The one where the admission has been made by the petition, clear admission. After that, what we say is this, madam, at para 7. And whereas the competent authority in ONGC deliberated the contents of the reply to show cause notice, it was observed by the competent authority that clause 16 of the contract doesn't specify the type of document or its commercial implication or the reasons due to which the forgery has occurred. And so the said clause does not have any such provision for letting go of such incidents. So this is the main ground. Messrs. Opel has also accepted this false submission of documents by email dated 22/2/24. Further, even this is the word sentence starts with the word further. Further, even, even after giving assurance that such lapses will not be allowed in future in its mail dated so and so, there was one more forged document submitted by Messrs. Opel pertaining to high mast, which was later confirmed by so and so Messrs. Kevin White, its email dated so and so. So this is an additional incident we are just incidentally taking note of. It's like while when your lordships pass a judgment, there are observations that your incidental observations that your lordships make. But the main ground is that you have not only committed forgery, you have admitted to that forgery. And the clause 16 does not give us the leeway to let go. It is a mandatory provision which we are bound by. So therefore, my lord, your lordship will certainly examine the matter. There cannot be any question of an interim order in this kind of matter. And in any case, interim will mean restoring status quo ante, which your lordships normally don't do in a.
Is this with immediate effect?
Yes. Para 10, madam. Line, fourth line from top towards the right is hereby terminated with immediate effect. And so far as my lord, the other aspects on merit, I am not troubling your lordship at the motion stage. We'll need to file, as I said, my lord, the main contract clauses have not even been annexed. These are issues which on merit
You have engaged the bank guarantee also?
Yes, on 17th we have encashed.
No, it has been credited.
On 17th it has been credited to the account of ONGC.
17th of March.
13th was the order of termination.
So let it be fixed on a short date. Give them a short time, then whatever is the outcome, follow.
Zarical and senior counsel. Assisted by MS.
Valentina Villapino,
Valentina and counsel for the petition.
Valentina has been enough.
Issue notice. Then I'm not saying much of the.
Yes, yes, no,
Mr. I. Chowdhury, Learned Senior Counsel. Assisted by Mr.
Yes, Chakravarti.
Learned Counsel, enters appearance on behalf of all the respondents and prays for short time to file affidavit. Stop. When do you want?
Your lordship is issuing notice, man.
Yeah.
But it's slightly voluminous, so your lordship will allow us 2 weeks, man.
Okay. That's fair enough.
2 is fair.
Praise Allah.
Let it be fixed immediately after Bihu vacations.
After 2 weeks.
Just one request, my lord. Let some legible copies be, extra copies be served.
I'll give it to you. I'll give it to you. I'll give you extra copies.
The copies, annexes are not readable at all.
For the court also.
Oh yes, I'll do that. And lordship, let them file in 2 weeks. We can file a response and the matter be taken up on the 24th of April or something like that. If it's all right with you. You want to?
We will file. We'll try to file it immediately before the Bihu vacation.
So that I can respond thereafter immediately.
28th April.
28th.
April, fine.
Okay, then you do one thing.
28th.
Praise Allah, huh?
We'll
let the counter affidavit be filed. Today is 21st.
Today is 21st.
On or before?
11th, before the Bihu vacations.
11th of April 2025. Stop. Thereafter, petitioners also permitted to file reply.
And the matter fits on 28th.
When do you want?
28th of April.
This the matter on 28th April.
Obliged. Obliged.
26.
Yes.
May I please, your lordship? Lordship, kindly the matter may be fixed for time being. My senior is taking up a matter in court number 5.
Notice maybe.
Yes, for hiding charge, isn't it?
Yes, lordship.
Outstanding dues.
Yes, outstanding dues.
Will issue notice.
Yes, ma'am.
Okay.
Heard, Mr.
W. Akhtar.
W. Akhtar, Learned Counsel for the petitioner. By this writ petition, the petitioner is claiming for payment of outstanding dues amounting to rupees 11,65,332.82. Stop. Issue notice. You are praying for all.
Yes, madam.
Mr. M. Chitial and Government Advocate enters appearance and accepts notice on behalf of all the respondents. Accordingly, notice on respondents are complete. However, extra copies, respondents are allowed to file affidavit. List up to 4 weeks.
64 of supplementary list. Motion.
Made, please, your lordship. Lordship, this matter relates to the arbitrary exercise in delimitation. What happened, your lordship?
Division of the division.
No, it is a different issue. The fact is that, your lordship, these petitioners are the inhabitants of village Narayanpur Part 2.
Yeah.
These inhabitants are the residents of village Narayanpur Part 2. Now, when the delimitation exercise was started, your lordship, initially the delimitation commission fixes the Gao Panchayat, and then every Gao Panchayat is divided into 10 wards. So at page number 18, lordship will find that in Algapur Katlichora constituency, your lordship, one GP, namely Narayanpur GP, was formed. So in name of LSC is Algapur Katlichora and name of the GP is Narayanpur GP. Lordship has got it. And ward number 6, lordship will see that ward number 6 will consist of Narayanpur Part 2. Now these petitioners are the residents of village Narayanpur Part 2. Now when the voter list was published, it found that the village Narayanpur Part 2 was given in a different Gao Panchayat, not in this Narayanpur Gao Panchayat. At that time, some people approached this honorable court, and after approaching, they have admitted that they have committed a mistake and they will issue a fresh voter list. Accordingly, a fresh voter list now they have issued. But what happened? These petitioners who are the resident of village Narayanpur Part 2, some of them who are the petitioners, they have been singled out and taken in ward number 7. They ought to have been ward number 6, but they have been taken to ward number 7. And the problem is that in between ward 6 and 7, there is another ward number 5. So they have no any geographical continuity with the ward to which they have been now shifted. They ought to have been in ward number 6, but they have been given in ward number 7. But that ward number 7 is not in contiguous. After ward 5, after ward 6, there in between there is ward 5 and then ward 7. Now they don't have any connectivity with the ward number 7. That is not permissible, your lordship. Now in that we have filed a representation. At best, if lordship can dispose it of with a direction to consider the representation, because anytime election may be notified also.
Lordship, it's a bench 5 matter. Lordship, similar matter has been going on in court number 9, the bench 5.
What is a bench 5?
Lordship.
Okay, then.
Then list it tomorrow, your lordship will pass an order. Since urgency is there anytime.
What, Mr.? Yes, right.
Monday. MS Lasko.
Oh, MS Lasko, Learned Counsel for the petition. MS?
P. Thapa.
P?
Thapa.
Thapa. Learned? Standing counsel.
Non lordship. Also, on behalf of S. Datta.
Learned Counsel appearing on behalf of Mr. L. Datta.
S. Datta.
S. Datta. Learned Standing Counsel?
PNRD.
PNRD submits that this is a bench 5 matter. Stop. We see to accordingly list before the appropriate bench.
On Monday, your lordship.
Before.
Oblige, lordship.
65.
24th, lordship. Fixed a date, your lordship. In the matter, any date lordship has given?
24th.
24th. 65 behind.
There's a Monday.
Lordship, oblige, lordship.
65 as well.
Lordship is holding up a progressive enterprise.
No.
Nehar, Notun Dehar.
Natun Dihar Mauza.
Yes, yes. No, he's getting confused with section 67. May please, Lordship. The challenge herein is basically a move of the government under the Food and Public Distribution Department to introduce transporters for transporting food grains from the FCI godowns to the fair price shops. Now, Lordship knows that there is an intermediary in Assam, that is the GPSs, the Gao Panchayat Samabala Committee, that is corporate societies. Now, the system that has been otherwise been in place is that it is these GPSs, the societies, who handle this particular activity of transportation from the corporation godowns to the fair price shop. Now, if a lordship will come to page 38, I'll just place the document that is under challenge here. Page 38, and then I'll place before lordship as to how this cannot be implemented. Page 38, lordship has that, 138. Now, this is addressed
138.
138,
Oh.
lordship. I'm sorry, lordship, 138.
Yes.
This is a document dated 4th of March 2025, bottom lordship will find, issued by the Additional District Commissioner, Food, Public Distribution, Consumer Affairs, Nalbari. Now, this is addressed to the secretaries of all the corporate societies of the Nalbari district. Now, the subject is regarding fresh online tender for selection of new transporters for carrying food grain, PMGKY rice under National Food Security Act. With reference to the subject cited above, I would like to inform you that instructions received from the government to initiate the process of fresh online tender for selection of new transporters for carrying food grains under the NFSA by considering the impact of route optimization result and to complete the process at the earliest through e-tendering. In view of the above, you are hereby instructed to submit immediately the previous court order documents, if any, as you are playing the role of transporter in this district for taking onward necessary steps in this regard. Your reply should reach understand within 7 days. Now, the purport of this letter is basically to inform the societies in the district of Nalbari that we are now going ahead to bring in transporters, private transporters for the transportation. If you have any documents to show that this should not be done, you should do it within 7 days, because as of now, you are handling this role of transporter, as if inviting us for a litigation. That is how this letter has been drafted. Now, I would say that this cannot be implemented. Why? If a lordship will come to page 130, page 68 first. There was basically a challenge at one point of time by all the districts, wherein the same move was challenged. That your lordship will find a batch of writ petitions were filed, disposed of by a common order, page 68, and the order starts at page 116.
Yes.
Lordship has come to page 116. Paragraph number 2. The core question that arises for decision in this group of writ petition is whether or not the decision of the state government to engage private parties as transporters for transportation of the PDS articles for door-to-doorstep delivery to the fair price shop is in consonance with the targeted Public Distribution System Control Order 2015, issued under Section 3 of the Essential Commodities Act. Since a common question of law arises for deciding all the writ petitions, I propose to dispose of the batch of writ petitions by this common judgment order. And finally, his lordships have passed an order at page 137 is the operative portion, whereby the Honorable Court did not interfere with this move of the government. The last paragraph. Page 137.
No, that is a division bench order.
No, 137 is a single bench. I'm sorry, Your Lordship. 131, Lordship. 131. The last line, 131. For the reasons stated herein above, this court is of the opinion that there is no merit in this writ petition and the same are accordingly dismissed. Now, this was assailed in the division bench. Now, division bench order that the Lordship has just seen, page 132, writ appeal number 249. This is relevant because this has been also referred to a recent order. Writ appeal number 249, 2018. And the order that has been passed, the Lordship will come to page 137. May I read, Lordship? Having regard to the facts and circumstances of the cases, and also considering the fact that the appellants are continuing to lift the distributed food grains from the designated depot, we direct the parties to maintain status quo in respect of the existing system of distribution of PDS commodities insofar as transportation is concerned till the final decision of the appeal. The appeals are still pending. The interim order is still in place. Now, if a lordship will come to a recent order that has been passed by this honorable court at page 139. This is basically in a district of Kamrup. Similar situation has happened, district of Kamrup, wherein similar NIT and this kind of letters have been issued by the authorities saying that we want to go ahead with introduction of transporters in the light of the fact that the judgment is still there. The bar is still existing. Now, what this honorable court has stated herein, if I may just read, at page 151. I'll just read also 2 pages. The petitioner's case is that the state respondents cannot employ private transporter contractors for lifting and transportation of essential commodities from the Food Corporation of India's storage depots to the godowns and to the fair price shop pursuant to NIT dated such and such, as the same is in violation of order 7.1, 7.11, 8.1, 8.3 of the Targeted Public Distribution System Control Order 2015, Read Order 20, Targeted Public Distribution System Control Order 2015. The petitioner's counsel submits that this is also in violation of the section 24(2)(a) of the National Food Security Act. He further submits that similar matters have been decided by the single bench of this court. The lead case being WPC number 6647/2015, wherein the petitioners who were similarly placed as the petitioner herein had made a challenge to the decision of the state government to engage private parties as transporters for transportation of PDS articles to the fair price shops in terms of the Targeted Public Distribution System Control Order 2015. The single bench, by judgment and order dated 21/9/2017, dismissed the writ petitions. However, a challenge was made to the same by way of a writ appeal, being WA 249/2018, the one I just showed to your lordships. Thereafter, the division bench, by order dated 3/9/2018, passed in WA 249/2018, had directed that the writ petitioners' appellants were to continue lifting and distributing the food grains from the designated depot. Further, status quo was directed to be maintained in respect of the existing system of distribution of PDS ice commodities, insofar as transportation of PDS commodities was concerned, till final decision was made in the appeal. Paragraph 6. On a perusal of the contents of the petition, this court finds that the issue to be decided is pending before the division bench of this honorable court. In writ appeal number, there have been multiple writ appeals filed. In view of the division bench of this court in WA 249, directing that lifting and distribution of food grains from designated depot should be carried out as per the existing system of distribution, this court is of the view that the NIT dated such and such cannot be acted upon till a decision is taken by division bench of this court in the above mentioned writ appeal. My case is squarely covered by these observations.
Here there's no NIT.
There is no NIT, but this letter is basically an invitation for the NIT and asking us to produce documents before them to show why this should not be acted upon. So therefore, I have to come before the lordships for an order to be placed before them to show that you cannot now proceed based on this notice for an NIT, because that you are increasing difficulties. So what my prayer is, lordship, this letter has to be stayed, or a lordship may pass an observation that in view of the division bench judgment, they should not proceed based on this particular letter of this at page 138.
My lord, in this case, my lord, it is premature because, my lord, no step has been taken for issuing the NIT, my lord. Only for they have been asked to produce any documents relating to this subject, whether there is any case is pending before the court or there is any court order, my lord. If all these are submitted by the petitioners, they may not go for the NIT also, my lord.
If the statement can be recorded, I think that will also suffice. Otherwise, my prayer is,
my lord, they can yes, this is a so notice to submit the document. Then in view of these, my lord, they can submit the all orders before the authority and they will take a decision, my lord.
So I am praying for a similar protection as has been passed in this single bench judgment.
In those cases, my lord, NIT has already been issued, my lord. That is why, my lord, court reacted in that.
The subject itself says regarding press online tender.
Yes, my lord.
Now, what is the need for the department to spend their time and money to go into the tender and then me again coming before this honorable court asking for a serious tender?
Mr. Sharma, learned counsel for the petition. Stop. the petitioners. This is which
Nalbari district, Lordship. Cooperative societies of Nalbari district.
are the different cooperative societies of
Nalbari
Nalbari district. And they are aggrieved by the communication dated 4/3/2025, written by the Additional District Commissioner, FPD&C and Nalbari, and addressed to the secretaries of all the societies
Yes, Lordship.
under Nalbari district with regard to fresh online tender for selection of new oblique transporters for carrying food grains within bracket PMG KY rice close bracket under NF stuff. Para. Learned counsel for the petitioners submits that similar matters
Yes.
have been decided by a single bench of this court, and the lead case being WC 6647 of 2025, wherein the petitioners who were similarly situated with the present writ petitioners had made a challenge to the decision of the state government to engage private parties as transporters for transportation of PDS articles to the fair price shops in terms of what order?
Lordship, paragraph 2. There was an NIT Act, Lordship will find at page 117.
No.
Lordship is referring to. Yes. Justice Suman Shyam's order, Lordship is referring to. There was a NIT issue, page 117.
Okay.
Top line.
For transfer of PDS articles to the fair price shops. Huh? Stop. The learned single bench by judgment order dated 21/9/2017 dismiss the writ petitions. Stop. However, a challenge was made to the judgment order dated 21/9/2017 by filing writ appeal number 249 of 2018, wherein the Honorable Division Bench by an order dated 3/9/2018 directed the writ petitioners oblique appellants therein to continue lifting and distributing food grains from the designated depots. Stop. Further status quo was directed to be maintained in respect of the existing system of distribution of PDS commodities insofar as transportation of PDS commodities were concerned.
Yes, Your Lordship.
Till a final decision was made in the said writ appeal. Stop. It is the case of the petitioner, a learned counsel for the petitioner, that the said writ appeals are still pending disposal and the interim order is still in force.
Yes,
Correct?
Your Lordship. Yes, Your Lordship.
Stop. Para issue notice. Mr. M. Chitia, learned government advocate. Enters appearance.
For 2 my lord.
Union Gogoi, Mr. K. Gogoi, learned CGC, appears for the respond number 1. Mr. M. Chitia, learned government advocate, appears for respond number 2.
2 to 7, my lord.
2 to 7.
2 to 7. Stop. Notice on respondents are complete. However, extra copies of which petition be furnished to the learned counsels appearing for the respondents are allowed to file affidavit. Okay. List after 4 weeks.
4 weeks.
4 weeks. Stop. Para On a perusal of the materials available on the court, comma, this court is of the considered opinion that as the related issue is pending before the division bench of this court in writ appeal number
249.
249 of
2018.
2018 and other connected writ appeals, comma, and particularly taking into consideration the order dated 3/9/2019 passed in writ appeal number 249 of 2018 that whereby direction is issued that the lifting and distribution of food grains from the designated ports should be carried out from the designated depots should be carried out as per the existing system of distribution. This court is of the considered comma the communication
Page 138.
communication dated 4/3/2025 written by the additional district commissioner FPT and CA Nalbari and addressed to the secretary, comma, all SS, triple S.
It
What
should be
is it?
GPSS, triple S it seems.
Huh?
It should be actually GPSS. I do not know what they have written. Gao Pansayat Samavai Samiti is what it should actually be.
GPS.
And WCCS is wholesale cooperative societies.
So it must be GPS.
Should be. Should
Okay,
be.
GPS, correct. Oblique WCCS
WCCS.
under Nalbari district shall not be acted upon,
Yes.
shall not be acted upon till the next written.
But shall not be proceeded further.
Don't say it will not be acted upon.
Yes, Lord. Oblige, Lord.
One unusual where Lord, item number 53 has become infectious, Lord. Your Lordship.
Mr. M.E. Montal and counsel for the petitioner submits that the present contempt. Why infractious?
Because we are Lord, protected by the respondent authorities in terms of the interim order passed by this honorable court.
In
passed by this honorable court in a writ petition, my lord, we have been protected.
Then you just withdraw it.
Yes, that can be.
Then you say, Mr. M.U. Mandal and counsel for the petitioner press for withdrawal of this contempt petition. Praise allowed. Contempt petition is accordingly closed on withdrawal.
Obliged.
This is my lord. In a land measuring of 7 bigha covered by dag number 322 and patta number 98 of Rongadi Reserve Village, my lord. It is in the Bipuria Revenue Circle.
Oh.
So this said land was a Miadi land, my lord. Thereafter, under the provisions of the Assam Agricultural Land Regulation of Reclassification and Transfer of Non-Agricultural Purpose Act 2015, the said land was reclassified as industrial land for non-agricultural purpose, my lord. So thereafter, my lord, see, he got the permission from the Revenue Authority and from the Pollution Control Board to operate the stone crusher unit. And the said land belongs to one late Sondhon Da. And thereafter, my lord, after his expiry of Mr. Sondhon Da, my lord, a lease agreement was executed between the son of late Sondhon Das and the petitioner, my lord. My lord will find the lease agreement at page 32. This is a lease agreement, notarized lease agreement, my lord. So while the petitioner was running the stone crusher unit, norms has been changed. Now the requirement is to submit a registered lease deed. So, my lord, accordingly, we have applied for registration of the said lease deed, my lord. My lord, will find the application at page 47. This is a letter written to the circle officer. Subject submission of registered lease deed in respect of industrial land. Sir, with reference to the subject cited above, it is to inform you that on 30/3/2018, a notarized deed was executed with Sri Gopal Das, son of late Sondhan Das, so and so, land measuring 7 vega covered by Doug number 322 and Patta number 98, and install a stone crusher unit. Due to change of norms of the government, now a registered lease deed is required for this purpose. Although we have applied for a registered lease deed online in the year 2022, however, the same has not been done yet, and hence we are facing difficulties in renewal of the stone crusher permit. On last meeting of stone crusher permit committee dated 19/10/2023, we are asked to why we do not submit the registered lease deed and when can we submit the same. As such, you are requested to provide the status of the said land and guide us how to execute the registered lease deed. So, thereafter, my lord, the DFO Lakhimpur division, he wrote a letter to the deputy commissioner, my lord. That letter, my lord, will find at page 50.
Okay.
The subject regarding renewal of stone crusher permit for the year 2024. Madam, with reference to the above cited subject, I have the honor to inform you that as per minute of the stone crusher permit committee meeting that held on 19/10/2023, communicated by the chairman cum conservator of forest Northern Assam Circle Tezpur of stone crusher permit committee white letter number so and so dated so and so, the permit committee had decided to allow renewal of permit up to 31/12/2024 in favor of Messrs. BB Construction is a petitioner here in my lord of Rongade Reserve, Harmuti, and Mrs. So and so, subject to production of registered lease deed on land and submission of up-to-date land revenue. Further, 2 numbers of prayer petition has been received from the proprietor of both stone crusher unit, along with up-to-date revenue receipt for the year 2023. And also, both the proprietor of stone crusher unit stated that the concerned circle officer of Bipuria Revenue Circle could not provide land details as the village of Rongade Reserve under Laluk Mauza is a non-cadastral village and cadastral survey has not yet been completed. So, proprietor of the stone crusher unit are unable to submit registered lease deeds and land at this moment. Therefore, I would like to request you to kindly look into the matter and issue necessary direction for onward necessary action. So, though, my lord, the reason for not giving the registered lease deeds is that this area in question is a non-cadastral village, but from the Jamabondi copy, my lord, which my lord will find at page 22, my lord. Page 22, my lord. Here, my lord will find Jamabondi of surveyed village, page 22.
Yeah.
So the land in question, where they are now denying to give me a registered lease deeds due to the reason of non-cadastral, but the Jamabondi shows that this is a surveyed village, my lord. And next page, my lord, page 24. Annex C, page 24.
Yeah.
This is the treasury salon whereby I have deposited the amount for reclassification of the land. The total amount I have paid, my lord, 2,45,000 for reclassification of the land to the industrial purpose, my lord.
Page 24.
Page 24. In 24, I have paid 99,000. Then page 25, I have paid 47,000. Then page 26, 99,000. So total, I have paid 2,45,000 for reclassification of the land for non-agricultural purpose. So now they are denying it only on the reason that this is a non-cadastral, my lord. So thereafter, recently, my lord, a communication has been made to us, my lord. Page 51. Page 51, my lord. Submission of necessary documents for renewal of your stone crusher unit for the calendar year 2025. With reference to the above cited subject, I am to inform you that as per the decision of the stone crusher permit committee meeting held on 17/1/2025, you are required to submit the following documents for renewal of your stone crusher unit. Please note that until submission of these documents and completion of the renewal process, your stone crusher unit is directed to remain closed with immediate effect. List of required documents: NOC from the Revenue Authority of the Deputy Commissioner Lakhimpur District regarding land documents, and an up-to-date income tax return of 2024. So since they are not able to process the registered lease deed, now the stone crusher permit committee asked us to give a NOC from the Deputy Commissioner, my lord. Accordingly, my lord, we have submitted a representation before the Deputy Commissioner to give us a NOC, my lord. That also they are not considering, my lord. When hereafter, my lord, by the impugn notice, case 54, the range officer Harmoti directed us to cease all the stone crushing activity.
Yeah.
So because of non-issuance of NOC by the district revenue authority, my lord, the forest officials, they are now asking us to stop the activity, my lord.
Yes, you get instructions. We'll take. How about the deputy commissioner?
Regarding lease permission, whether he has applied for lease permission or not, that is not there. He only file a representation. He have to apply in the proper format as like of sale plots. For registration of a lordship, immovable property like land and
Just
flats.
see if you are supplied. We'll give you some time to heard Mr. B. Kaushik. Heard Mr. N.J. Khatania, learner counsel for the petition. I'll not issue notice, I'll keep it
Yes,
in the
my lord.
motion stage. Mr.
Okay, I'm representing 6 and 7. Okay.
And Forest, Mr. I. Batakul, learner standing counsel Forest Department. And Mr. K. Gogoi, learned additional senior government advocate. Appearing for the state respondents shall receive their respective instructions. When do you want?
After 10 days.
Sorted no, next week, my lord.
Next week.
Next week is not possible.
Last week of April also anything.
Okay. This on 4th. 4th April.
Yes, for as soon as 8, my brother will appear.
I'm appearing for 8 as Burma.
Pollution control board.
Okay, and shall receive the respective info, S. Borough for the pollution control board as well.
Obliged.
67.
May it please the lordship. The challenge herein is cancellation of my technical bid. Now, on a very flimsy and arbitrary ground, I must say. The lordship will kindly come to page 32. 32 is the tender. Now, this has been issued, page 32. Now, this has been issued by the health department for supply of, the lordship will see the item category, cardiac monitor with defibrillator.
Where is that?
Page
Okay.
32.
Item category.
Item category, yes, your lordship. Lordship will see just above that total quantity. So 69 quantities of cardiac monitor is the requirement. Now, the bone of contention herein is this: minimum average annual turnover of the bidder for 3 years. 100 lakhs, that is 1 crore, lordship. So this is the clause where the entire dispute is. Now, if your lordship will kindly come to page 34. 34, serial number 1, the conditions, just below that chart. The minimum average annual financial turnover of the bidder during the last 3 years, ending on the 31st March of the previous financial year, should be as indicated above in the bid document. Documentary evidence in the form of certified audited balance sheet. Lordship will just mark this because this is where the issues are. Documentary evidence in the form of certified audited balance sheet of relevant period or a certificate from the chartered accountant, cost accountant, indicating the turnover details for the relevant period shall be uploaded with the bid. I'm just pausing here for a moment. I'd just like to address your lordship on this point. To fulfill this requirement, I can produce documentary evidence of two nature. One would be the audited balance sheets. And the second is a certificate from the chartered accountant indicating the turnover details. So I can submit any one of them. I can submit both. But these are the documents based on which the tendering authority will achieve that satisfaction that, yes, I have met this particular clause. Now, if your lordship will come to page 48. The last date of submission was 29/1/2025. Now, pursuant to submission of our bids, these are all online bidding process. So this is the one clarification that has come. I may just read that, Lordship. This is dated 11/2/2025. May I just read that, Lordship. You are requested to provide the supporting documents clarifying the below mentioned points. And then they just mention a few documents herein that I am supposed to submit. Seller's response description below. Respected sir, with reference to the subject mentioned above, we like to state that we had submitted all the documents as per the bid requirements, and now we are resubmitting the same as required by you with regards Progressive Enterprise, that is the petitioner. Now, based on this, the documents that we had already supplied, we have again given it to them. Since they wanted these documents, we again supplied them. Now, from page 49, we again resupplied based on this clarification that they showed. On 11/2/2025, subject submission of required documents for bid clarification. We submitted the entire documents that they asked for. Now, where the issue has arisen, may I just place those documents, Lordship? If a Lordship will come to page 58, this entire bunch of documents is the documents that we have supplied. Now, they are finding fault with us is regard two particular issues. So, therefore, may I just point page 58? I just got that, page 58. Yes. Now, page 58 is the CS certificate. Now, if you have seen the clause, it says a CS certificate. It doesn't refer as to whether it has to be addressed to anyone. Nothing. It simply says it has to be a CS certificate. There are certain tenders where they make it a particularly, they indicate that address to so and so. Herein, nothing of that sort has been written. It just simply says a certificate has to be submitted. Now, this is the certificate which has been issued by the CA. Now, if a Lordship will see the address in that letter of certificate, it has been addressed to Assam Medical Service Corporation Limited. Therein, a bona fide mistake has happened. That address should have been otherwise to the health department, though it has not been stated anywhere, but yes, ideally it has to be addressed to them, but this certificate was addressed to a different authority. Now, this has been annexed. However, the purport of this certificate was to indicate that whether I meet that particular eligibility criteria or not, and I meet that with flying colors. What is required is 1 crore. My average is 43 crores. So therefore, there is no dispute at all on that aspect as to whether I meet that criteria or not. Instead of 1 crore, I have got 43 crore. Another issue that they are finding fault with, we'll also see the bottom. CA Vishal Bothra. Now, there is no signature. But then there is a UDIN. Now, UDIN, if I may just place one document, Lordship. The UDIN happens to be the unique document identification number. From 2019, the technology has changed, things have become digitalized. These are all digitally signatured documents. So, based on the regulatory authorities' directions from 2019, CAs do not sign, but rather these are all digitally signatured, and the UDIN number is provided. All chartered accountants are registered under this portal, and whatever documents they issue, that is available under this UDIN number that can be verified. And this is basically to maintain that no misrepresentation happen. In fact, this about UDIN, if I may just read that, it has been noticed that financial document certificates attached by third persons misrepresenting themselves as CA members are misleading the authorities and stakeholders. ICAI is also receiving numbers of complaints of signatures of CA being forged by non-CA. To curb the malpractice, the Professional Development Committee of ICAI has implemented in phased manner an innovative concept of UDIN, Unique Document Identification Number. All certificates are being made mandatory with effect from 1st February 2019 as per Council's decision. So therefore, the CA certificate need not have a signature. In fact, to curb that menace of misrepresentation, now UDIN numbers are provided.
Okay.
So this is one aspect. Now the other aspect, Lordship has seen that clause. It said audited balance sheet. If you find fault in this document, I still have in my backup the audited balance sheets that also we had supplied. That your Lordship will find. Or Lordship will just note that because these are all, I have flag marked them. From page 60 to 63 is the balance sheet for the year 2021. 60 to 63 is the balance sheet for 2021. Page 65 to 68 is the balance sheet for 21-22.
Okay.
Page 71 to 74 for the year 22-23. And page 77 to 79 is for the year 23-24. So I am covered from both the sides. I provided the CS certificate as well as I provided the audited balance sheet also. Now your Lordship will see how they have treated my bid. For that, if your Lordship will come to page 103.
Yeah.
103 is the evaluation result after the technical bid. Lordship will see item serial number 6, progressive enterprise, disqualified.
Yes.
And Lordship will also mark serial number 1, Acure Medical Private Limited, qualified. They have made a private respondent hearing. Now, against this rejection, immediately on the same day at page 104, we wrote an objection letter to the authorities. Page 104. Therein, we have also stated that we had submitted all the documents. There could not have been any rhyme or reason for rejecting our bids. Now, based on this representation, at page 159, the authorities now gives the reason for the rejection at page 159. Landscape size page. Yes, Lord. Now, Lordship will see at the right-hand side top refers to our representation of 24/2/2025. And the response description is rejected. Bidders' average annual turnover from CA. The submitted document is not properly addressed and lacks the CA's signature, making it non-compliant. So they took into regard the CA's certificate, found fault with it on two aspects, that it was not addressed properly, and number two, it does not have a signature. If they are not abreast with the modern technological developments, I cannot help it. 2019, the authorities have stated it has to be UDIN number. And the other aspect is that it has not been addressed properly. Now they lost sight of the fact that I had also submitted the balance sheets.
Yeah, Google.
On
This is
Wednesday,
the-
my lord,
this
I
is
will
the
have
clear case that
I've already informed the authority. Let it be on Wednesday, my lord. I will have
And also another aspect, page 162, they have opened the financial bid. The private respondent, page 161, if your Lordship will see, on page 161, on 10th of March, 2025, the financial bid has been opened and Lordship will see Acure Medical Private Limited, L1, 2 crores 12 lakhs. Page 162. First line.
Yeah.
Acure Medical Limited. Total price is, Lordship has seen, 2 crores 12 lakhs. I have categorically stated in my paragraph 16, I have disclosed my figure now because the financial base is open. I have quoted 1 crore 51. The state is going ahead to make a loss of 60 lakhs now because what I have submitted is amounting to 1 crore 51 and they are going ahead with the L1 at 60 lakhs above. These are covert ways of corruption, I must say.
Oh, no, it cannot be. It's a two-bid system, my lord. First, it is a technical bid. There is a first hurdle. You will have to come. Otherwise, my lord, we would have opened the financial bid first. Then,
No,
my
I
lord,
understand.
Yeah, this
But
cannot be.
what
this
is
cannot
the
be a ground
picture?
for argument? But
No, no.
my lord, going by the, my lord, two documents that he has placed, of course, my lord, the provision is or, either or. So he has placed both in the writ petition. We will have to check whether, my lord, those documents are actually uploaded, my lord, in the along with the technical bit. So
Okay.
on Wednesday, I will have the inspection, my lord.
Till then, LOA may not be issued.
But then, my lord, Lordship will consider the interim on that day.
No,
Nothing will
if-
happen within
But
3
then
days.
if you issue the work
Then
order,
what
It
happens?
will not be issued, my lord. I have already informed the authority.
Then let the
Because-
undertaking be recorded in the
No,
court.
it may not be recorded.
No, why
Lordship
is not
will
to be
consider
recorded?
My lord, interim order on the next day.
There
That may
creates the
be recorded.
difficulty, Lordship. That is the difficulty.
My lord, moment the interim order is passed, my lord, I will concede, my lord, if it is uploaded, my lord, if there's our fault, my lord, I will concede on that.
no, but in
You
the
must have
meantime,
some
if,
faith on me.
if the work order is issued,
I have informed them. I have
third
said,
party
my lord,
rights will
by
be accrued.
10:30 I have informed that this is a litigation pending today. It will be listed today.
Lordship, I undertake to
1
be.
minute, 1 minute. Yes.
I am making the undertaking, my lord. Lordship may not record it, but they will wait, my lord, definitely. And they have
Why
also
not
stated,
Unless I record it.
my lord, I have informed them. They will not.
That's
go
what I'll just record it.
Then Lordship will stay it, my lord, not my on my why on my my lord, word that I should give undertaking. But Lordship may record that. Lordship will consider interim on Wednesday, my lord.
No, Lord.
When I said to them the litigation is
I will stay the further proceeding till Wednesday.
Yes.
I'll make an
continue, my
I'll
lord.
make an observation
And
that
Lordship, the-
continuance of the interim order shall depend on the instructions received by you.
And I will not seek adjournment on that day. That is my undertaking on Wednesday.
But A.
That's a
Sharma, not
different
responsible for the petition. I'm not issuing notice then in this stage.
No, notice will have to be issued on next day, my lord, provided my lord
No,
we
that's why
contest
at
the
this
case, because
stage,
there is
today-
a L1 bidder now, my lord.
Today I'm not issuing
Not-
notice.
LOA may not be issued.
B go, huh? Huh? কোন? হুম। What did I say, Mr. B. Gogoi, Learner Standing Council, Health Department.
Here, Health Department.
Health Department shall receive instructions. Stop. List the matter on 26th. Stop. Okay.
Lordship will record the tender number.
Till the next returnable date.
Page 32.
The respondents
Page 32.
shall
Right hand side
not.
top corner.
You have not finalized yet, isn't it?
No, L1, my lord.
Financial
whatever
bid is open,
financial
Lordship.
bid is there, it has been open. Now, my lord, with the approval of the government, they will be issuing the LOA. It will take time.
Next stage will be LOA only, Lordship.
Yes, of
Already
course.
7-8 days has gone. Any moment they will issue the LOA.
Shall not issue the work order
Yes, Lordship.
in
As regard tender number, that number is at the top
where's
side.
the tender number?
Page 32, right hand side top corner.
As
GM.
regards tender number GM oblique 2025 oblique B oblique 5795142 dated 8/1/2025
For supply of 69 numbers of.
for supply of 69 numbers of cardiac monitor with defibrillator. Huh?
Yes, you know.
Within bracket Q2. Huh? Till the next sentence end. It is also made clear that the continuance of the interim order shall be subject to the instructions received by the Learned Standing Council Health Department.
Yes, you are. Obliged, Your Lordship. Deeply obliged.
68.
Please, Your Lordship. But if GMC has directed us to close our unit, which have been operating under a valid trade license.
Yesterday's matter.
Yesterday's matter, Lordship, if I recall.
Yeah, Bora.
Well, this has, yesterday, Lordship, the parties have been corrected. The another issue is that the party is a partnership firm. Partnership firm has come before the court without disclosing the fact whether it's a registered partnership or in a
Lordship,
unregistered
partnership agreement was handed over to me by evening, so I'm supplying a copy of him, the registered partnership.
and it to be registered before the firm. If it's not a registered partnership, then it will be.
I've supplied him a copy, Lordship.
You have to register before the firm registration.
This is a reconstituted one, Lordship. Already registered. The reconstituted one is registered. And total there are 4 partners, 1, 2, 3, and 4. And in this agreement, Lordship, the 3 and 4 have been retired. They have retired
from the year 22, Lordship. 17th November 2022, Lordship.
Okay.
And 1 and 2 are continuing, Lordship.
Where's the order?
Lordship.
Where's the order? If you order.
Issued the order, there are 2 orders issued, Lordship. Firstly, show cause notice was issued, Lordship. Show cause notice is at annexure 2, page 17, Lordship. Annexure 2, page 17. Yes, Lordship. May I read, Lordship?
Yes.
Whereas you have running an IMFL bonded warehouse.
Yeah, that I've seen. After that, did you file your reply?
Yes, Lordship. My reply is at next page, that is page 18, Lordship. 18 and 19 is my reply, Lordship. In my reply, initially I have apologized for not responding within the 7 days due to holy vacations, Lordship. Subsequently, Lordship, we have stated that we are ready to, we reiterate our commitment to renew the trade license.
Is your godown closed or not closed?
Not yet, Lordship. Not yet, Lordship. We have not
That's the
closed.
pertinent question. Whether you have closed the go down, whatever is the go down, if petition also go down. But the trade license, the issue is the trade license. Lordship will turn to page number 16, the trade license. He has defrauded the GMC. He says this is not a go down. He is in a wholesale business. Because while clicking the website, this is a easy to, these are doing business. This is online process. What he has not clicked the go down and the square feet related, because whether the square feet goes, the price goes up. He has taken out a wholesale, what you will see in the second line, liquor wholesale.
Where?
Well, third line, my lord. So and so for a business type, liquor wholesale. He shows as a liquor wholesale, but actually he is running a go down. It's a go down of 15,000 square feet to 20,000 square feet. He should have taken out as a go down. And in the moment you click the go down in the website, then comes the area. He has not clicked there. He has taken out a license of only 8,750 rupees by paying it. That's the issue. That is the issue, my lord. That's why, my lord, in the so-called notice, what will come to the next page, 17, paragraph number 2. But the area square feet of your bonded go down premises is not added in your existing trade license. Specifically, the notice has been, so-called notice has been given. You have clicked, you have defrauded the GMC that amount. You have taken out a license of go down, taken a license of warehouse when you are running a go down of more than 15,000 to 20,000 square feet. That slab you should have clicked it. And there, that's why the GMC has received a lesser amount.
Lordship, there was no such slab. We have applied it online, Lordship.
Yes,
online, certain amounts we need to feed it. We accordingly feed it. And this business has been continuing since the year 1988-89, Lordship. This year also we have renewed 2023, 24, we have renewed, Lordship. 24, 25, we have renewed. They have never came forward. Only on the last hour, on 18 March, they came up with a closure notice, Lordship. My every financial closing accounting is going on, Lordship. Hundreds of workers are employed in that. Let them give a formal reply, Lordship, and we have already replied to that notice, and we are ready to comply with any irregularity, if any, Lordship. We are ready to comply.
No, we will not be benefited if we close the business, man.
Because, Lordship, 5 crores, 5 crores per month.
We need the revenue.
Correct.
Thing is that's why, my lord, that's why, my lord, Lordship will turn to the page number 17 again. Paragraph number 13. The value you have to pay as a fine, that is written. In this regard, such type of irregularities under Assam so and so the Guwahati Municipal Corporation Amendment Act so and so under section 404 per day, 5,000 rupees is and 19 for 90 days must be 4,50,000. Fine has to be imposed on such so and so. He is now have to pay 5,000 rupees daily fine. That amount we want it. That he have to pay. That irregularity he have to correct it. And that is the position of 5. If he close the business, we are losing it, my lord.
Lordship, only 10 days are left, Lordship, for this financial year to close down.
Yes.
31st March, we have to reapply, renew, Lordship. Whatever irregularity, if any, we can get it corrected, Lordship.
No, that is the subsequent. That is for the year, earlier year, my lord.
Oh, for the earlier
year. They have to pay the fine. You run your business.
Let them pass a reason order. Let them pass a speaking order on our representation, Lordship. Because they have simply.
Where's your representation?
What's the page 18? In our representation, we have simply asked them
It is not
to
a representative, it is a response to the
lordship,
notice.
reply to notice, lordship.
Okay, heard, Mr.
Ek apoti.
Learned counsel for the petition. I'll issue notice at this stage.
Lordship.
Or you want instructions?
No, instruction is there, my lord.
So you want to file affidavit?
I will file an affidavit.
Issue notice. Mr. S. Bora, Learned, standing counsel. Oh, state. Bukalia, you have
No, my lord, I am appearing for the state also.
state also.
State is
Mr.
DC, lordship, deputy commissioner.
No, I am appearing for respondent 1, 2.
Learned standing counsel, GMC. Affairs on behalf of respondent 1, 2,
4 and 5.
4 and 5. And
Apparently
Mr.
there is
J.
no three.
Bukalia, Learned government advocate, appears for the respondent number 3. Stop. Huh? Notice on respondents are complete, however, extra copies with petition be furnished. Huh? Respondents are allowed to file affidavit. Liz, how long do you want to take?
2 week time, my lord.
1 week time you take it.
Not.
Or 2 weeks.
2 week time will be.
Okay. Release the matter after 2 weeks. Till the next written date. The impugned letter dated 18/3/2025, written by the Deputy Commissioner in charge East Zone Guwahati Municipal Corporation and addressed to the petitioner's enterprise shall remain suspended.
Deeply obliged.
This is the paper.
You want a date?
Lord, will fix a date. In the meantime, I will find it.
Okay, when do you want? 9th?
Lord.
9th.
Okay.
One of production list, Oval Projects Engineering Private Limited versus ONGC.
My lord, before my senior colleague starts, my lord, though we have not filed a caveat, but I have instructions to appear in this matter, my lord. This is connected to the matter which was taken out in the morning, termination of contract. So.
But this is not, I'll not appear to talk. I'll not appear, don't worry. I'll not be so cheap.
I've been instructed to appear in
It's
this
okay, he
matter.
doesn't the power, but doesn't matter. Lordship, this is against the order now, this is the order which they have initiated. I think they are just after my blood. Looks like they initiated under the provisions of the Integrity Pact. Lordship, the impugned order is at page 62, page 4. Annexure 4, page 62. Lordship, I'll not bother Lordship. They have quoted clause 8.33, that by virtue of that, they've already terminated my contract. Lordship has already gone through that. Now, Lordship, they go to section 3 of the at page 64. Section 3 of the Integrity Pact. Disqualification from tender process and exclusion from further contracts. That is section 3 of the Integrity Pact, which they want to evoke. It's quoted, if a bidder before a contract has been awarded has committed a transgression through a violation of section 2 or any 2 or in any other form, such as putting his reliability or credibility as a bidder into question. This is about the bidder, so we do not come in here. I'm a contractor. Then one will find if a bidder or contractor has committed a transgression through violation of section 2, as such put his reliability or credibility in question, the principal is entitled to exclude the bidder contractor from future contract award process. The imposition and duration of the exclusion will be determined by the severity of the transgression. The severity will be determined by the circumstances of the case, particularly the number of transgression, the position of the transgressors within the company hierarchy of the bidder and the amount of damage. The exclusion will be imposed for a minimum of 6 months and a maximum of 3 years. A transgressor is considered to have occurred if the principal, after due consideration of available evidence, concludes that there is no reasonable doubt about its possible. The bidder accepts and undertakes to respect and uphold the principal's absolute right to resort to and impose such exclusion and further exception, and undertake not to challenge or question such exclusion in any ground, including lack of hearing before the decision. Lordship, this is absolute also. Before the decision to resort to such exclusion is taken, this is undertaking is given freely and after obtaining independent legal advice. Then if the bidder contractor can prove that he has resorted one to damage or to recompensate the damage caused by him and has installed a suitable corruption prevention system, the principal may revoke an exclusion prematurely. Now, Lordship, again, this is section under this action is taken now. And clause, then they talk about the drawings, they talk about forgery, then allegation mentioned above, and 6, whereas considering all the allegations mentioned above against the firm, the competent authorities approved conducting inquiry for banning. Now they have approved conducting and for banning business dealing with the firm in accordance with the banning policy of ONGC. The competent authorities approved this, they have said this. Whereas it has been decided to put the firm on provisional suspension for a period of 6 months, pending inquiry of banning proceeding. During the period of banning proceeding, the firm shall not be eligible to bid directly or indirectly through joint venture, this, any other thing, in any tender of ONGC and their offer, if any, in any ongoing tender process shall not be considered, including consequences mentioned in ONGC's policy for banning provision suspension of business dealings. Now this is issued and they are going to ban me for 3 years. This is not a show cause notice. It is a provisional banning order. Now, what is the effect of this banning? I am out of business. I'm tarnished. And what happens is that my business dealings, once I'm banned from my organization, I can't bid anywhere. All my business dealings will go. And if Lordship looks, this action under Section 3 of the Integrity Pact can be only done if I have violated Section 2 of the Integrity Pact. Now, Integrity Pact deals with what? It's an anti-corruption thing. And Lordship will look, commits the Section 2. None of these things are applicable. That is, I've given it at page 69, Section 2 of the Integrity Pact. The bidder take all measures necessary to prevent corruption. He commits himself to observe the following principal duties during his participation in the tender process and during the tender execution. The bidder contractor will not directly or through any other person or firms offer promise or give any of the principal employees involved in execution of tender or execution of the contract to any third person material in. I have not done. Lordship is clear. I will point it out to your Lordship. Now, these things are not done. I have not been given a show cause notice. They're suspending me for 6 months. Whereas one of the punishments starts from 6 months to 3 years. So one part without being established whether I have violated or not has already been implicated on me. And Lordship, again, I rely on the Supreme Court decision. This is nothing but blacklisting. And Gorkha Mocha, where the Supreme, has been given a copy? Extra. This is extra.
Just for the time being.
You can take it or I'll serve it to you anyway. Lordship, this petition and this decision, Lordship will look at paragraph 27, where Supreme Court has clearly said we are therefore of the opinion that it's incumbent on the part of the Department of State to show cause notice to the competent authority intended to impose such a penal or blacklisting, so that to provide adequate and meaningful opportunity to the appellant to show cause against the same. However, we also add that even if it's not mentioned sufficiently, but from the reading of the show cause notice, it can clearly infer that such action would propose, it would fulfill this requirement. Now, Lord, but here is not the case. This is not the paragraph, Sanjana. What nonsense are you doing? Paragraph 31. So Benny had marked. This is what got up. Then you have marked it, then you have removed it. Lordship, I'll just give the page. Paragraph 32, Lordship. Paragraph 32. He's underlined. He's gone. This is contents. Necessity of supervision. I have got it from there, declared it from there. And this one you gave what?
Anyway.
The other decisions also.
Yeah, well, a basic issue is that
no show cause.
You are aggrieved by clause 7.
Clause 7, and no show cause has been issued, and they're banning me straight away, which is, it's like putting a death nail to my business altogether.
Yeah, exactly.
And that I need a hearing, because the Supreme Court says very harsh. You should not take any other. I am not asking for a stay for my bank guarantee, which they have done. They've done it. It's all right, Lordship. I'm not that. But here, where you condemn me to death, before that, a show cause is bound. And this provisional suspension is nowhere to be found, Lordship. In this kind of drastic things.
7, clause 7.
Yes.
Clause 7
of the what you call without prejudice. I
Without
don't know,
prejudice.
I don't know whether it is a notice.
Perhaps your lordship, the morning the other matter was moved, and your lordship has issued notice in the order of termination only without staying it. But my lord, if your lordship comes to the order, present order, which is under challenge here, page 64. Page 64, my lord. Lordship will find there is a clause 8.3.7 of the contract, and the contract agreement has not been annexed. It says as a consequence of termination, what the employer can do. Now, my lord, this particular clause 8.3.7 says if a contractor's contract is terminated, and as a consequence of such termination, a proceeding for banning will be initiated, where notice will be served, hearing will take place, and examination of that aspect will be carried out. But during pendency of that proceeding, temporary or provisional banning is permissible in view of clause 8.3.7.
Where?
My lord, I am giving a copy of the contract. Perhaps
I think I have a next.
Yes.
I think I have.
Yes, paragraph 60, page 64. Lordship will find
it's
quoted. If your lord, I'm reading it, man. in all cases of termination herein set forth, the obligation of the ONGC to pay shall be limited to the period up to the date of termination. Notwithstanding the termination of this agreement, the parties shall continue to be bound by the provisions of this agreement that reasonably require some action or forbearance after such termination. Then, my lord, in case of termination of contract herein set forth, except for 8.3.31 and 8.3.32 and or annulment of the contract due to non-submission of performance guarantee, following action shall be taken against the contractor. One, my lord, ONGC shall conduct an inquiry against the contractor, and consequent to the conclusion of inquiry, if it is found that the fault is on the part of the contractor, then they shall be put on holiday. That is, neither any tender inquiry will be issued to such contractor by ONGC against any type of tender, nor their offer will be considered by ONGC against any ongoing tenders where contract between ONGC and that particular contractor as a bidder has not been concluded for a period of 2 years from the date of the order putting the contractor on holiday is issued. However, the action taken by ONGC for putting the contractor on holiday shall not have any effect on other ongoing contracts, if any, with that contractor, which shall continue till expiry of the terms. Now, my lord, this is the final order of banning. Now, pending completion of inquiry process for putting the contractor on holiday, ONGC shall neither issue any tender inquiry to the defaulting contractor nor shall consider their offer in any ongoing tender. Now, by this order, this is the provision, this is the provisional banning. So, my lord, here for this provisional banning, no notice is required. It is as a consequence of termination, and your lordship in the matter which was moved in the morning, your lordship has not stayed the termination order. The termination order exists as on date, and this action that is of 19.3 is a consequence of termination. So in any case, my lord, I am led by senior counsel Mr. I. Chaudhary in this matter. If we were informed about this, maybe he would have been there. But my lord, sorry. So my lordship may take up this matter on Wednesday. He will be there, and we'll also get all the instructions. My lord, for 2-3 days, nothing will happen.
No. My reputation is stake.
So,
You
my
are
lord,
banning me and my reputation is stake. And
my lord, this is a order passed in consequence of termination. The contract clearly provides. Lordship will see that is why this particular provision is quoted in the order of provisional banning. If a lordship takes up termination first as a consequence, because my lord, 8.7.3.7 clearly says consequence of termination, my lord. If the termination is under challenge, there is no stay. There is no stay order. But now, as a consequence of termination, this can be done. There are two parts. Consequence of termination can lead to two things. One, banning for 2 years. For that, an inquiry will be done where the contractor will get the opportunity, notice, show cause notice, reply, everything, formally everything will be done where it will be given the opportunity. That is for 2 years. If it is established that there is any requirement of banning. However, this particular two, it is a contract which the contractor, the writ petitioner has agreed. This is a condition of contract. Number 2, pending completion of the inquiry process, putting the contractor on holiday, ONGC shall neither issue any tender inquiry to the defaulting contractor.
So this is what you can do. You will not issue any tender inquiry to the defaulting to the petitioner, nor consider their offer.
Yes.
But here what you have done, you have suspended the petitioner for 6 months, correct?
Yes. And this is not under that. The punishment is from 6 months to 3 years. It's not under 8.3.7.
6 months to 3 years, that is after the inquiry.
After the inquiry.
Prior to the inquiry, clause 7, you have you put him under 6 months.
So, my lord,
how can you do that?
My lord, it is a provisional banning for the purpose of inquiry.
No.
This is a provisional banning.
Read your 8.3.7.
Yes.
Roman 2.
Roman 2, pending completion. So, my lord,
pending completion of the inquiry
for putting
process for putting the contractor on holiday.
Yes.
ONGC shall neither issue any tender inquiry to the defaulting contractor, nor shall consider the offer in any ongoing tender.
Yes.
Okay.
Yes.
That you have the liberty to do that.
Yes.
How about clause 7 in your without prejudice?
So my lord, this 6
You have
months,
decided to put the firm on provisional suspension for a period of 6 months pending inquiry for banning process. Can you
that is
do
why,
that? Can you do that?
my lord, this is the period, during that period of provisional
No,
suspension.
whatever it is, you file your affidavit.
My
You
lord.
file- I'm not staying the inquiry process. I'm not I'm not staying the whole inquiry, what you call this, I don't know whatever it is, it was called without prejudice. So
My lord,
this,
it
this
is,
document, I'm not suspending the whole document. I'm suspending clause 7 of the document.
my
That's
lord,
all.
my lord, if the clause 7 of the order is suspended, then is clause 7 says that it is a provisional banning pending inquiry and during that period. So here in 8.3.7, there is no.
Where is that provision for provisional banning?
My lord, this is putting the contractor on holiday.
Holiday is
This is, my lord, putting the contractor on holiday
means blacklisting.
Yes, provisional, my lord, banning.
Okay.
My lord, lordship will
state
take
a
up this.
suspension order.
My lord,
I'm staying only clause 7.
Clause 7.
my lord, this is a consequence of this order. This is a consequence of termination, pending inquiry. And during inquiry, now here the appropriate clause nowhere says the period how much that inquiry may take place. So here we have
6 months. You're already punishing me. The initial period.
No,
initial period is already been punished.
That
yes, it's from 6 to 3 months.
That
3
is
years.
the banning process, and it has made clear that
Imposed 6
during
months
the
already.
period of provisional banning, the firm shall not be eligible to bid directly or indirectly through any so and so. This is exactly what clause 2 says.
Okay, I've heard
Neither shall issue any tender inquiry to the defaulting contractor, nor shall consider the offer in any ongoing tender.
M. Hazarika, Learned Senior Counsel,
So this is
Yes, they were.
Learned Counsel for the petition. I'll issue notice. I'll fix this case on the same date, which we have fixed on the other case.
28th of April.
Mr. S. Chagavati.
Mala.
Learned Standing counsel. No,
No, we are not standing
Learned
counsel for ONGC. But my lord,
and just appearance.
lordship may take up this matter on Wednesday, my lord.
Let it get- what is your hurry? Why are you so vindictive?
No. On Wednesday, since Mr. I. Chaudhary is appearing, he has appeared in the other matter, he is appearing in this matter also.
Doesn't make a difference even if he appears on Wednesday or he's not appearing today also. On Wednesday also, I'll pass the same one. I'm not satisfied. I'm not satisfied.
Lordship will record my
Because
submission.
what I've seen is 8.3.7.
Yes. 8.3.
Okay, I can give you one chance. We'll list it on Monday. If Chaudhary can come, we'll take over. Otherwise, passing orders today.
My lord, Monday he will be in Itanagar. So
I don't know.
Tuesday, my lord.
No,
In that case, Tuesday.
I have problems on
Tuesday, my lord.
I have problems on Tuesday.
In that case,
Lord,
Wednesday,
let
my
it be
lord.
the 28th of April.
My lord, in that case, let it be on Wednesday. Let it be on Wednesday, my lord. Because in the meantime, these 2 days, there will not be much difference.
But the scar will be there.
Scar or whatever it is,
Scar will be there.
satisfy
The
your
scar will
lordship
be there.
and will take the instruction as to
Take your instruction.
whatever it is, let it be on Wednesday, my
Let
lord.
them take 2 weeks. 3
Instead,
weeks.
now lordship has proposed to take up this matter on Monday. Instead of Monday, I'm suggesting let it be on Tuesday when Mr. Chaudhary will be there. And if my
Why?
senior,
I have problems.
in that case,
Chaudhary.
Wednesday, my lord.
No, Lordship,
in that case,
but till
2-3 days will
Wednesday,
not-
the suspension order has to be stayed, Lordship.
2-3 days,
I am
2-3 days.
2-3 days, even you will not, nothing will happen to ONGC. ONGC is not on the list.
So, my lord, the
Consequences not.
There is there any in the writ petition that within 2 days there will be a fresh bid where he will
I'm not
petitioner
talking
will be
about
on.
bid. I'm talking about.
So, my lord, the question is, what is banned? Banned is the contractor will not be permitted.
May I just point out that?
My lord,
May I just point out that what he's saying is absolutely incorrect. He is saying
first
that
of all, my lord, this particular contract, the contract agreement has not been enclosed with the writ petition. And my lord,
all the relevant.
So, my lord, may I submit that let this matter be taken up on Wednesday, my lord.
Lordship, I will also point out that he is talking. He is misleading this honorable court.
No, my lord.
8. I will tell you,
object to that, my lord.
8.3.7 talks about putting a holiday for a maximum of 2 years.
Yes.
Whereas, Lordship, in the impugned tender or note letter, what is said, it is under section 3 and the yes of the please do not let me finish. It talks about section 3 of the IP code and the suspension period. Lordship will look at page 65, involves and capacity of the ONGC may be banning for the time period of minimum 6 months and maximum date of suspension of 3 years from the date of suspension. This is not under 8.3.7. This is under the IP.
Lordship will have a look at the order. It has quoted.
Quotation, forget, this is what it says.
In that case, my lord, I'll satisfy your lordship. Let it be taken up on Wednesday, man. There is nothing.
Okay, let us come on.
Till the suspension will be stayed till then.
Wednesday, man.
We'll consider on.
Wednesday.
Lordship on suspension may be stayed.
My lord,
I'm being maligned, Lordship.
My lord, on Wednesday, let the order be passed in presence of the senior counsel who is there, and we'll apprise your lordship.
On request made on behalf of I. Chaudhary, and it's a counsel for the respondents. List
on 26th.
Okay. 26th.
Till then, Lordship will let the suspension.
We'll see that. We'll see.
Lordship, till
Nothing will happen.
No, only till only till.
I've made my mind clear.
Yes.
17 of daily list. Motion.
How many motion matters are there? I won't think of anything.
But here, I also pray let it be on Wednesday. Here, letter of acceptance has been issued. Notice to proceed with the work has been issued in February. So he's challenging it now in mid of March. On Wednesday, I will have the
on request, big over.
PWD go.
Let us standing on list the matter.
Only thing, my lord, he will have an extra copy today, just so that I can communicate.
All right, ma'am.
There was no time, no. Okay, you informed them.
My lord,